It should be working now. Oh, yes, it does. It has. Okay, and then that, yes, it's working now. Perfect. Thank you so much. Okay, bye. Right, it's worked. So I think he had to do something from his end. Yeah, and then let me just call Xavier. Hey Xavier, it's Kitty. So I just spoke to Patrick and we've got it working now. So I'll just make it public if you wanted to just check that it's all good. Okay. Now. Working? Okay, perfect. I'll make it private again. But yeah, that should be all good now. I'll tell muted. Okay. Yeah. Okay. I'm not too sure how. Yeah, okay, no worries. Thank you. Bye. All right. This has worked now. It's private. I don't know if you, well, it's nearly 9:30, so they're gonna come in soon anyway. So I'll leave this here. It's pretty easy to follow along. So you just have to dial into the Darwin Supreme Court Level 3 conference room.
So it isn't already dialed in?
Yeah, but just whenever you have to set it up next time.
Okay.
And this is set up, and then yeah, you literally just follow this. But now that you're in, you won't have to log in again because if you're the one doing it tomorrow, and you just have to keep it muted until everyone's in court and you've gone to get the judge. And
I looked at the judge?
well, I had to but I'm not sure. I'm not too sure how it's going to work. I have no idea what's going on over here.
Is the judge appearing in this one?
Yeah, I think so. Oh, not the Coronial judge, I think. Okay, maybe it's this legal argument. I'm sorry, I have no idea what's happening over here.
Neither do I. I don't know what's going on.
But just keep it muted until court started.
Do I need to worry about changing the view because it's bar only if there's a judge?
Yeah, I'd probably put it to judge/bar if there is a judge. Maybe just speak to them when they come in. But and then I don't know why there are people on now. That's private. Two minutes. Yeah, it got up to like 150 when I was in court yesterday.
Should we turn our microphone?
It is. Oh.
Take issue with it here.
And I'll just skip over them.
Is that okay?
Good chance to.
You're doing something.
That's all. It's a Thursday, Edwards. Such a danger that was you're just sitting there enjoying the action and suddenly the computer's going to boom. Oh, good right there. G'day. Okay. And hello. I'm listening for this.
Nice to meet you.
Nice to meet you, sir.
Yes,
Yeah, Luke
we
and I
before.
met, yeah.
Well, you guys can instruct at the bar table too, can't you? The lawyers on screen.
There's all our learned friends.
Oh, chairs. This way I can pass notes, you know, if something going to really help. No other instructors. Oh, yeah, reset.
She's there, is she?
No, that's,
She's there.
yes.
That's fine.
Hello?
Bear with me. We didn't,
Or just the AG first. Attorney General. Probably.
Yeah, I got it, Joseph. No, oh yeah, you will. I got them.
Please enter the conference ID, followed by the pound or hash key. Please hold while I try to connect you.
The suspicion that would attach to it.
I mean, I guess you can't see it because it's the screen, but they have this kind of wall-sized monitor in kind of a proper corner setup. Thanks.
Yeah, I can see the domino effect.
Got a water bottle, so I won't need that. Which email do you want me to send the parties' names to? Okay, great. Thanks, Jamie. Bye.
There are some plugs if you need them.
I will need one.
At least we know the.
Orbs chambers video room is Junior Forbes Chambers.
Silence, all stand. Honourable Court is now in session. Please be seated.
Matter of Lee Bowens in the Territory Coroner.
Yes. So who do we have?
May it please the court, Your Honour, my name is Boyle and I appear for Mr. Lee Bowens on the application.
Right. Thank you, Mr. Boyle. And we have
the court,
the
please. My name is Doyle with a D. And
Mr. Doyle.
I'm appearing with Mr. Officer for the applicant to be joined as a second plaintiff, Constable Zachary Rolfe.
Right. Thank you.
If the court pleases, Your Honour, my name is Coleridge and I appear for the defendant, the Territory Coroner, who files a submitting appearance.
Thank you very much, Mr. Coleridge.
If the court pleases, I'm not sure if you can see me, Your Honour. My name is Game and I appear with Miss Edwards for the Attorney General intervening.
Yeah. Thank you, Mr. Game.
And may it please Your Honour, my name is Freckleton and I appear with Miss Bernard seeking intervener status for the Northern Territory Police Force.
Thank you.
For please the court, Nick Verpill, I appear with Ms Wild for the North Australian Aboriginal Justice Agency Limited, applying to intervene.
Yes, thank you, Mr. Nick Verpal. And we have somebody from the families.
Good morning, Your Honour. My name is Bowe, spelt B-O-E, and I appear with Ms Bowe for Alice Walker, Joseph Lane and Rakesha Robertson seeking to intervene.
Yes, thank you. Do you mind if I refer to that group of people as the families?
Yes, thank you, Your Honour.
Right, you don't mind?
No, I don't mind. I'm sorry.
All right. Thank you. So we have appearances. Could I just start with the issue of joinder? The Attorney General has indicated no objection to the joinder of the plaintiff or any of the other interveners. I haven't heard from the plaintiff, but the plaintiff has expressed no opposition, at least in written submissions, and it does appear to me that that Mr. Rolfe has established an entitlement to be joined as a plaintiff, and that the other interveners, that is, the Attorney General appears as of right, NARJA, the Northern Territory Police and the families have likewise established sufficient entitlement or interest to be joined as interveners. So can we take that as read and I can simply make those orders joining Mr. Rolfe as a plaintiff and giving leave to the others to intervene?
The only issue with that, Your Honour, and it's Boyle here for Mr. Bowens,
yes,
is that in the submissions filed on behalf of the Northern Territory Police Force, there is a claim in the final paragraph of the submissions that they ought to be entitled to their costs in the event that the application is unsuccessful. And we would say that it should be a condition of any grant of leave. The rest of the interveners in there, or proposed interveners in their submissions, effectively say they will not seek any costs and are effectively undertaking to bear their own costs. If it's necessary, I can take Your Honour to some authority for the proposition that an intervener, in effect, ought not to be entitled to their costs, even where their contentions are ultimately accepted.
Yes.
But that's the only condition I'd put on that.
Your Honour, that issue has been superseded by communications latterly. The application for costs on behalf of the Northern Territory Police Force, should they be successful in the outcome that they are seeking, has been withdrawn.
All right. Thank you very much for that. So, Mr. Boyle, that takes care of any objection you may have?
Yes, I think that's right. Subject to anything that Mr. Doyle might have to add for his part. But there's no other issue from my perspective, Your Honour.
All right. Mr. Doyle?
Thank you, Your Honour. For my client's part, we would respectfully submit that there is a discretion to be exercised by the court about the status of an intervener. It's not a binary status. The court can impose conditions or can limit the extent of the intervention. There could be debate about whether the matters that give rise to the standing of the interveners in the inquest would suffice for the purposes of this proceeding. But so long as the grant of permission to intervene is limited at this stage to making submissions on this application, we wouldn't oppose such an order. I have in mind...
Well, that is what this proceeding is all about.
Yes, I have in mind preserving the position about whether they would be joined as parties having rights of appeal and so forth.
As far as I understand it, this is an application for judicial review. It is pretty much a single issue application for judicial review. So a grant of leave to intervene will simply be that they intervene and make submissions on that limited issue in this proceeding. What else could there be?
Well, Your Honour, I was just mindful that an order that joined them formally as parties might give them some status.
They're simply getting leave to intervene in the judicial review proceedings.
Very well, Your Honour.
All right, thank you. Well, I will make those orders. An order joining Constable Rolfe as a plaintiff and an order giving leave to NARJA, the Northern Territory Police, and the families who'll be more particularly described in the order, to intervene on the judicial review proceeding. All right. And could I just ask, because I can't really see counsel, I can see Mr. Boyle because he's big on the screen, but everybody else are tiny little figures at the bar table. So when you speak, could I just ask if you announce your name and party, well, name and who you are appearing for, so that I can follow the conversation more closely. A couple of things I wanted to say before we begin. So having dealt with the joinder issue, there's a very large volume of material has been filed. Like one affidavit in particular goes to 3,000 pages. And I'm not minded to accept all that material into evidence. A lot of it seems irrelevant to the issues on this particular proceeding, namely the judicial review of the coroner's decision or ruling, firstly. And secondly, if it's in evidence, I have to read it. And if I have to read all of that material, then you won't get a decision for a year. So the proposal I have is this, and that is that I will accept into evidence the body of the affidavits that have been filed, minus the annexures, all of them. And if and when those annexures are referred to in a relevant way by counsel in submissions, we'll simply mark them as being included in the affidavit as part of the evidence. Does anybody have any strenuous objection to that course of action?
Your Honour, could I just be heard on that?
Sorry, who is speaking?
It's Mr. Game. Sorry, Your Honour. I'll try and remember to say that each time. So,
Mr. Game, yes.
So yesterday we communicated with the solicitors on Mr. Byron and separately the solicitors for Mr. Rolfe that we objected to most of the material in their affidavits, in the body of the affidavits and the annexures, as being irrelevant to the questions at hand.
I tend to agree.
So one of the affidavits is particularly problematic, which is Miss McNally's affidavit. And it's not just the annexures. The affidavit is quite argumentative about all sorts of things that have got nothing at all to do with the questions. And Mr. Officer's affidavit is of the 17th of November. That is her affidavit, but Mr. Officer's affidavit of the 17th of November is mostly objected to as well, but it's not nearly so argumentative, but it's largely irrelevant to the issues. And Mr. Rolf's question is purely a question about I'll call it a question of statutory construction, and we're not disputing he has an interest to argue it, nor are we disputing that Mr. Owens has an interest to argue it. And in both respects, we simply we accept the matters that are set out in the submissions prepared by Mr. Freckleton, in which he explains in which particular respects there may be a relevant exposure of each of those. That's really the only question. There's a separate issue raised, leave to amend, by Mr. Bowens. That's a separate issue, but again, that issue is described in his submissions as a freestanding question of statutory construction. We'll be objecting to that amendment, but again, no material could possibly be relevant to a determination of that question, which is framed as such a question. So there's that. We also have an affidavit in which we annex some relevant material, and you will have to see some of those annexures, but they're just by way of giving some context and no more than that, Your Honour.
Yes, Mr. Game, as far as your affidavit is concerned, if and when those annexures are referred to, then obviously we'll accept them and read them. I don't think that is problematic. That falls within the proposal that I've already outlined. As far as the Mrs. McNally's and Mr. Officer's affidavits are concerned, I tend to agree. To the extent that they were relevant at all, they would have been relevant only to establishing an interest for the purposes of the joinder applications. And that's now been done essentially by consent.
Yes.
So, sorry, Mr. Doyle, there's no need for those affidavits, is there?
Well, Your Honour, I was going to suggest this. In light of the position that my learned friend indicated in his submissions, we accept the objections. I can hand up a note of the objections. We wonder whether the easier course will be to simply allow the affidavit subject to those objections, and that will neatly demarcate the issues. If I can hand up a note of the objections.
Mr. Game, are you satisfied with that course of action so we can get on with it?
One last thing, Your Honour. Ms. McNally's affidavit is, shall I say, far more argumentative, and it's a very long affidavit, and almost all of it is inadmissible.
Well, you've notified those objections, and those objections are accepted, so let's...
No. Ms. McNally is Mr. Bowens's...
Oh, I'm sorry, Mr...
So you'll have to hear from Mr. Boyle on...
I'll hear from Mr. Boyle on that. Mr. Boyle?
Yes, well, insofar as those objections go, I don't read paragraphs 4 to 8 of Ms. McNally's affidavit in any event.
Yes.
And then there's an objection taken to effectively from paragraph 10 through to the end of the affidavit on the basis of relevance. And I hear everything that's fallen from the learned friend and from Your Honour this morning. But in my submission, that material was there having regard to the unique position of Mr. Bowens, whereby he has not yet answered any questions before the coroner. He's not effectively had an objection, or he's had an objection determined, but in the context of Sergeant Kirkby's objection, in which he joined through his counsel at the time.
I'm sorry, Mr. Boyle, can I just stop you, because I don't want for this to go on for very much longer. Firstly, as far as relevance is concerned, I do not need to be taken to any material that was before the coroner. It can be accepted that questions either were asked or will be asked, that either have been objected to or will be objected to, and that a ruling was made, and that ruling, if it's to stand, is likely to apply to further questions of that nature. I don't need to decide any question about the relevance of those questions or whether they would give rise to a penalty privilege, if that applies, or anything like that. This is simply an application for judicial review of the coroner's ruling. So, having said that, that would be the basis on which I would determine the objections as to relevance. Is it an acceptable course of action that the affidavit of Ms. McNally's affidavit be accepted subject to my ruling on objections as to relevance?
Yes, Your Honour, it would be.
Mr. Game?
Yes, Your Honour.
Okay. Well, we'll deal with it on that basis. Okay, so, well, I've already then said what I consider about relevance. Similarly, in the Attorney-General's submissions, those submissions contain a lengthy and very helpful, I might say, history of events leading to the Royal Commission, into deaths in custody, the introduction of the Coroner's Act, a background of events leading to the inquest. And no, I'm not being critical of that at all. It was extremely helpful to put matters in context. Everyone can take it that I have read all of the submissions, but there's no need to go, as far as I'm concerned, into any of that to be repeated in oral submissions, except to the extent that it is directly relevant to the interpretation question. That's just an indication, really, from me. The final matter I wanted to talk about this morning before we begin submissions is that I have read all of those submissions. They're helpful, and I will obviously read them again and read them very carefully. However, I query the necessity for oral submissions, comprehensive oral submissions from all counsel. My proposal would be for one lead counsel, possibly counsel for Mr. Rolfe, you can work it out for yourselves, to make oral submissions for the plaintiffs, and one lead counsel to make oral submissions for what I could loosely call the contradictors, and for the other counsel then to simply get up and have their say in relation to anything additional that they want to say, without the need to repeat the primary submissions that are being made by lead counsel for plaintiffs and contradictors. With this caveat, I should say, Mr. Neckverpel, and that is I do note that NAJA's position on the construction is similar but different to the Attorney-General's, and you will need, presumably, to develop that position.
Yes, Your Honour, although I can certainly do that within the framework of what Your Honour's just identified, because a lot of the ground is the same, it's just where we get to.
Yeah, to the final position, all right. Well, does anybody have any sort of strenuous objections to that course of action?
No, Your Honour, and I think Mr. Doyle and I had effectively agreed to adopt that kind of a course from our position as counsel for plaintiffs anyway.
All right. And as far as the contradictors are concerned, will that be, Mr. Game, will you be taking the lead on that, or do you need to discuss it with your colleagues?
Well, I think I will be. I haven't discussed it, but I think I will be, would be the answer to that question.
Would you like me to leave the bench for a few minutes so that counsel can talk about it with each other?
No, I think it's fine. I think. Sorry?
Sorry, the families are content for that course, Your Honour.
Oh, thank you.
The Northern Territory Police Force also, Your Honour.
Right, thank you. Families in the Northern Territory Police Force, and I've already heard from Mr Neckerville. All right, well, then we can get on with it. Thank you. So we'll call upon Mr Doyle.
Thank you, Your Honour. Might I just attend to that matter of housekeeping in relation to Mr Officer's affidavit by handing forward a letter from the Northern Territory solicitor dated 22 November 2022, which sets out the extent of the objections.
All right, thank you. I won't make that an exhibit. I'll just receive that so that I can rule on the...
And so that my learned friend Mr Game can understand that the letter refers to certain paragraphs, and I've simply handwritten next to them the exhibits that are caught by those paragraphs. So it'll be apparent from the letter with the manuscript markings which paragraphs and exhibits are excluded.
So that will just go with the affidavit and,
Yes.
and will inform what is in and what is not in.
Thank you, Your Honour, for
All
my
right,
hand
thank
forward. And so, subject to that qualification, I wonder if I might tender the three affidavits of
Yeah.
Officer. The first, dated 10 November 2022. The second, which attracts those qualifications, is dated 17 November 22. And the third is dated 22 November 2022.
Well, the three affidavits of Mr Officer, minus the annexures, and subject to the, I suppose, exclusions in the letter of 22 November 22 will be Exhibit P1.
Thank you, Your Honour. In light of Your Honour's intimations, I had intended to address you on the procedural background and context, but I'm going to proceed directly to the legal argument.
Thank you, I appreciate that.
Put shortly, the issue for determination is whether penalty privilege is a basis, quite apart from Section 38, upon which a witness who is being examined on oath in an inquest under the Coroners Act 1993, Northern Territory, is entitled to refuse to answer a question. If the answer to that question is no, in other words, if penalty privilege is not a basis so to decline, there are two possibilities. The first is that the reason for that is because Section 38 of the 1993 Act is addressed both to self-incrimination privilege and to what I'll be referring to as penalty privilege. In other words, the penalty privilege is only available to the extent that it is engaged by Section 38. That, as Your Honour has already noted, is the position of the Attorney-General for the Northern Territory, intervening as of right. The other alternative is that Section 38 is not addressed to and is not engaged by a claim of penalty privilege, but that either Section 38 abrogates penalty privilege or the Act construed as a whole has always abrogated penalty privilege, or perhaps even put another way, penalty privilege was never capable of being raised in the context of an inquest. That, as we apprehended, is the position of NAJAR intervening. In our respectful submission, the court should hold that penalty privilege is a distinct ground, separate from Section 38, for the refusal to answer a question. But if the court is against us, we obviously urge that Your Honour adopt the Attorney-General's position rather than NAJAR's position.
Yes.
In order to resolve the question of statutory interpretation that's posed by that issue, in my respectful submission, it's relevant to understand, first, the status of penalty privilege as a legal concept. That will be relevant to the technique that the court should adopt in determining whether or not it is available in an inquest. In other words, characterising it or describing the nature of the privilege might affect the process of statutory interpretation upon which Your Honour should embark. It will also be necessary, in my respectful submission, to consider separately the nature of jurisdiction exercised by a coroner, and Your Honour will appreciate that there are coroners and there are coroners, in the various states and territories, but there are some broad propositions about the powers of coroners which we'll address, Your Honour, on before coming to the specific...
In your written submissions, you rely on a number of provisions in the Act
Yes.
for the proposition that it is a curial process.
Yes.
And you say that the result of that is that a penalty privilege is independently available unless abrogated by the statute. Is that right?
That's so, Your Honour. Your Honour's encapsulated the argument in a nutshell, but I will take Your Honour to some of those authorities.
Thank you.
Your Honour, I was proposing to address you in this manner. First, on the question of the nature of the privilege, I proposed to address you on 7 decisions, 4 decisions of the High Court, and I'll just give them short names because the parties will be well familiar with them.
Yes.
Pine Board, Morris, Daniels Corporation and Rich against ASIC, and 3 decisions of lower courts. First, the full federal court decision in a case of ABCO, that's ABBCO. Second, the full federal court decision in a case of Fruchinier, which is spelled F-R-U-G-T-N-I-E-T.
Yes, but I didn't know how it was pronounced.
Neither do I, but I thought I'd be bold.
Okay.
I thought if I hesitated, it would be a disaster. And finally, a single judge decision of the South Australian Supreme Court in a case of Bell. Your Honour, there are multiple lists of authorities flying around. All of those cases are on our list, but might I hand you a folder with those 7 cases in it?
All right, thank you very much. That would be handy.
Then, Your Honour, after addressing those cases, I propose to touch on the body of law concerning the nature of the powers of a coroner before turning to the specific context of the text, context and purpose of the 1993 Act when first introduced into law in this territory, and then the context, text and purpose of the amendment in 2002, which introduced the current form of Section 38, which Your Honour might appreciate replaced a predecessor provision which expressly preserved a privilege against self-incrimination. The 2002 Act made some other consequential amendments, but that's the primary amendment. Your Honour, so that Your Honour knows where I'm going with those submissions, might I briefly indicate the propositions that we contend for. The first proposition that we'll seek to demonstrate is that the High Court has recognised penalty privilege to be a distinct privilege, attracting the principle of legality, thus requiring that it be excluded expressly or by necessary intendment in both judicial proceedings and non-judicial proceedings. For that, I'll take Your Honour to Pine Board and Morris. Next, we'll submit that in respect of the observations in the case of Daniels Corporation, which are plainly directed to the ruling in Pine Board, the proposition in Daniels Corp that there seems little reason why a penalty privilege should be available in non-judicial proceedings and that it is not a substantive rule of law are first obiter propositions. Secondly, we do not concede and submit that it can be debated whether they are seriously considered dicta. But thirdly, even if they have that status of seriously considered dicta, in our respectful submission, what the Daniels Corporation dicta do not do is cast doubt on the status of penalty privilege as a common law right arising presumptively in judicial proceedings.
Sorry, you say they don't cast doubt on the proposition...
On the status of penalty privilege.
Sorry, that penalty privilege is...
A common law right.
Common law right.
Presumptively arising in curial or judicial...
Presumptively arising in curial or judicial proceedings.
And more than that, Daniels Corporation does not limit the availability of penalty privilege in a curial context to cases where a penalty is sought in that very proceeding.
No.
We say that, therefore, although the effect of the seriously considered dicta, if it be that, is that penalty privilege cannot be regarded as a substantive rule of law that applies in a self-executing fashion, even outside of curial contexts, it nevertheless has a significant status in a curial context, and it is more than a mere rule of evidence. It is
Does your argument depend on the acceptance of the proposition that the coronial proceedings are curial in nature? I mean, is that a fundamental underpinning? If that goes, does the whole argument go?
Certainly that's our primary basis. Don't shy away from that, but we do put a qualified alternative, and it is that in Pine Board, and I'll take your honour to this in a moment, the plurality did point to the particular significance of the context being examination on oath before a judicial officer, and we would submit that even if the correct approach is, even if, Your Honour, we're persuaded at a general level that coronial inquests are judicial, whatever that might mean in this context, where there is an examination on oath, we would say, even if the principle of legality isn't detracted, that is a circumstance which, as a matter of implication, brings with it penalty privilege, and that
Where a person is examined on oath.
yes,
That's what you say.
before a judicial officer. Now, they're only very subtly different ways of putting the argument, but it allows
You
for
say there could be situations, so even if the coroner's court is not a curial process or procedure,
Yes.
Doesn't matter, if a person is being examined on oath, which they are in the coroner's court,
Yes.
then you say Pine Board is authority for the proposition that penalty privilege is presumed to apply in those circumstances.
We can't put it precisely those terms because Pine Board proceeds from a different premise, but Pine Board does attach importance to the application of, the context of examination on oath before a judicial officer. And so if Your Honour is ultimately persuaded that after Daniels Corporation, really all bets are off, if I can put it colloquially, and one starts with a blank page, we would say to Your Honour that the first thing that goes on the blank page is the oath, and that carries with it by dint of...
Okay. So that is that argument comes in if it's necessary for the statute to confer.
Yes.
All right, thank you.
So, now I accept that's a harder argument for us, but we do put that as an alternative.
Just let me make a note of that if you don't mind. That applies if necessary to form. Okay.
And can I put one further slight alternative, and that is that we do submit that although if Your Honour were to hold that the coroner's court is a judicial proceeding or whatever the relevant test might be, we would submit that Your Honour won't need to resolve the status of the Daniels Corporation obiter in non-judicial contexts. But if Your Honour were persuaded that the coroner's jurisdiction cannot for these purposes be described as a judicial proceeding or a curial context, we do say that the observations in Daniels Corp are obiter. They did proceed without regard to the decision in Morris, and whilst there might be limits to what Your Honour can do with this submission, we would formally submit that the obiter is wrong and that...
Bold submission in the Supreme Court of the Northern Territory.
It is, but I make it as a formal submission in case the matter were to ever go further. And I think I'm obliged to do that, albeit I fully...
Yes, I'm sorry, I wasn't, well, I was being facetious.
The next proposition is that Rich doesn't alter any of the propositions that we make about the limits of Daniels Corporation. The next proposition is that insofar as the full court of the Federal Court in Frutigny did purport to hold, or I shouldn't say hold, did purport to observe that in all contexts, even including curial contexts, the question is whether penalty privilege is implied rather than abrogated. We submit that must be obiter in the context of Frutigny, and we respectfully submit wrong if it goes that far. And following upon those submissions, we submit that the case of Bell in the Supreme Court of South Australia signals the correct approach in the context of a coroner's court, namely starting presumption that the privilege is available where there's an examination on oath and the search is for express or necessary express words or necessary intendment by way of abrogation. That's a long run up to what we say is the correct approach, and I'll then submit that applying that approach in 1993, it could not be concluded that penalty privilege was excluded expressly or impliedly, and further, that the introduction of an amended Section 38 and with it consequential amendments to Section 41 did not alter that position. As I say, our fallback proposition, if Your Honour is against us generally, is that Section 38 should be taken to encompass penalty privilege. Might I start then, if that's convenient to Your Honour, that proposed manner of address?
Yes.
With the decision in Pine Board. And for the transcript, I'll give the citation. 1983, 152 CLR 328. So that will be in the folder that I've handed forward to Your Honour.
Thank you.
Can I start by drawing attention to the provision that was in issue, which is set out in the decision of Justice Brennan at page 348. Page 348 and 9. It commences at the bottom of page 348. Your Honour, I well appreciate that what was in issue was a so-called Section 155 notice under the old Trade Practices Act. It's important to note that subsection 1 of that provision was premised on the chairman having reason to believe that a person could furnish information, if I can put it broadly, relating to a matter that may constitute a contravention of the Act or is relevant to the making of a decision by the Commission under a particular section. Thus, the very reason for and basis for a Section 155 notice was to gather evidence that might establish, or not, depending on its content, a contravention of the Act.
Sorry about that. So you say the reason for the Section 155 notice was, I just lost track of that there, my computer went...
To gather evidence that might establish a contravention of the Act. Now,
okay.
Plainly enough, the notice is not a curial proceeding, it's simply a notice issued without connection to any court proceeding to a recipient. The next feature to notice is that subsection 5 provided that a person should not refuse or fail to comply with such a notice to the extent that they were capable of complying with it. Subsection 7 then provided that a person was not excused from furnishing information, etc., on the ground that the information or document may tend to incriminate the person. But it went on to provide that that material could not be admissible against the person in any criminal proceeding other than a proceeding under the section. And a proceeding under the section would simply involve a contention that someone hadn't complied with the notice.
Yes.
Or in the case of a body corporate, in any criminal proceedings other than proceedings under the Act. Now, there's that slightly different treatment of an individual and a company, meaning that in the case of an individual, even if the material showed a criminal offence under the Trade Practices Act, it couldn't be used, although it was slightly broader permitted use if it was a corporation. But might I just draw attention to the nature of the privilege, if you like, engaged by subsection 7, expressed simply by the words tend to incriminate the person. It doesn't, for example, say by way of the commission of an offence or a criminal offence. It's left unstated. Now, I mention that because, of course, Your Honour has a similar argument to deal with in the context of section 38, because the word that's used there is criminate, but without describing what it is that is the object of the crimination, if I can put it in that way. So having shown Your Honour the section, if I could take Your Honour to some passages in the joint judgment of Acting Chief Justice Mason and Justices Wilson and Dawson, starting at page 332. And at page 332, in the third substantive paragraph, about point 6 of the page, their Honour said that...
Just wait till I find it, if you don't mind. Sorry, third
paragraph starting the issue.
Got it, thank you.
Their Honour said that the construction of the section presents a particular problem. It's caused by the express reference in section 1557 to the abrogation of the privilege against self-incrimination and the absence of any reference to the privilege against exposure to the imposition of a civil penalty. Now that telegraphed their Honour's conclusion that as a matter of construction, it was only addressed to self-incrimination privilege. For completeness, Your Honour will see on the next page, 333, that it had been held in a full federal court decision by one of 3 judges, Justice Smithers, that the language of the expression privilege against self-incrimination was broad enough to capture penalty.
Sorry, where's this?
At about point 6 on page 333, there's a reference to a decision of Justice Smithers.
Yep.
Now, he was one of 3 judges in that Melbourne Home of Ford case. He held that the reference to self-incrimination encapsulated penalty privilege as well, but Justices Frankie and Northrop didn't proceed on that basis. They held that the penalty privilege only applied to giving answers on oath in judicial proceedings or in procedures relating to such proceedings as, for example, discovery. Does Your Honour see that at the bottom of...
I do. I'm not sure I follow it, but I see it.
At all events, that's simply just by way of background.
Yes.
One of the additional issues, apart from whether either of those approaches was correct, was whether penalty privilege could even apply to a corporation. That issue is flagged at page 334, but if Your Honour comes then to page 335, about halfway down the page, the plurality said that as will appear, this case is susceptible of determination on other grounds. In other words, they didn't decide the question of whether a company could ever claim penalty privilege. Just to jump ahead, Your Honour might know that in a later decision, EPA and Caltex, the High Court held that self-incrimination privilege wasn't available to a company, and drawing on that, in Daniels Corporation, the High Court appears to have held that for that reason, or by parity of reasoning, nor could a company ever avail itself of penalty privilege. So in a sense, the premise has been pulled out from under the analysis in Pine Board, but the analysis remains significant in my respectful submission. So at 335, in the passage I've just taken Your Honour to, Their Honour said they were content to assume without deciding that the privilege against exposure to conviction for crime and the privilege against exposure to a civil penalty was available to a corporation. Now, from here commences the relevant analysis. Their Honour said it was well settled the party cannot be compelled to discover that which, if answered, would tend to subject him to any punishment, penalty, forfeiture or ecclesiastical censure. Now that was a reference to what Lord Justice Bowen had said in the case of Redfern and Redfern, which is there cited. Their Honours on the next page at 336 referred importantly in my respectful submission to a discussion by Justice Dean when he was sitting on the Federal Court of Australia in a case of Refrigerated Express Lines Australasia against Australian Meat and Livestock Corporation. I won't read to Your Honour the whole passage there, but what the plurality are referring to is a passage by Justice Dean where he said there are two different cases. One is where the proceedings are for a penalty, and in that context, the court won't order discovery against the defendant. Another, described as the second situation in the last 4 lines of that long paragraph, is where the proceeding is not for a penalty, but the party fears that discovery might tend to expose them to a penalty. And the plurality said in that second situation, the order will be made, that is an order for discovery, and the party against whom the order is made may object to the production of particular documents or to the provision of particular information on the ground that it may tend to expose him to a penalty. By respectful submission, that's very important to see that the High Court has endorsed what Justice Dean said, and I'll take Your Honour to numerous authorities of the Federal Court which have never questioned this proposition, save perhaps for the overturn in Kumanjayi, which appears to suggest that if a penalty is not being sought in the very proceeding, that in a sense there can be no assumption one way or the other about the availability of privilege. Now the next proposition in the very next paragraph is that the plurality unpacked what Lord Justice Bowen had said in Redfern by saying that although the rule is expressed as one which relates to discovery, it's necessarily a reflection of the law of privilege. And the second point they went on to make is...
So where's that?
About point 8 of the page on 336.
Because although the rule is necessarily a reflection of the law of privilege.
And about 5 lines down, quite obviously they are 4 different aspects or grounds of privilege. In other words, there are 4 distinct privileges, or a privilege with 4 heads, but they're separate from one another. The next proposition, and Your Honour will need to note the very last paragraph on that page, we do not agree, and then if Your Honour turns over, that it is a special invention of the courts of equity devised for application in suits for discovery, etc. And then about 15 lines down page 337, the better view is that equity looked to the existing model of the common law and applied the rule which it had established Can I come then to the next paragraph commencing accordingly? The construction of 155 is to be approached on the footing that the privilege, and I'm paraphrasing, is A, not confined in its application to discovery and interrogatories, B, available at common law as well as in equity, C, distinct from, though often associated in discussion with, privilege against exposure to conviction. Then, importantly, they're on to say this, before turning to section 155, we need to deal with one further point, the submission that the privilege against exposure to penalty is confined in its application to testimonial disclosures in judicial proceedings and is inherently incapable of application in non-judicial proceedings. Now, I emphasise that because, in effect, the court is saying, well, at its narrowest, it's a doctrine that appears to apply to testimonial disclosures in judicial proceedings. We would say that's probably broader than examination on oath. It might extend to an affidavit that's ordered by the court, but certainly examination on oath is within the heartland of that concept. But what the court was going on to consider is, well, is it broader than that? And the court said in the very next sentence that there was a body of authority to support the proposition that it was confined to testimonial disclosures, and the court refers to that authority over the next page or so. Then the court points to the competing line of authority, which is to the effect that it is generally capable of application subject to exclusion.
Yes, but, sorry, are you talking about the passage in page 338? Talking about Kempsey and Justice McTiernan?
Yes.
Isn't that, doesn't that refer specifically to the privilege against self-incrimination?
It does.
And only that?
It does. But the plurality treated it as bearing upon the availability of penalty privilege in a non-curial context.
Okay.
Then, if I could take you over to the foot of 339, and then on to 340. In fact, probably more relevant to consider what starts in the paragraph that commences underlying.
Okay.
Underlying the conflict is a controversy regarding the nature of the privilege. Then, if I can ask Your Honour to read in due course the second to last paragraph on the page, which is a reference to the other side, a stream of authority, the privilege against self-incrimination stands apart from other forms of privilege. So adverting to the possibility that self-incrimination privilege might be of a lesser status than other forms of privilege, and referring to the argument that it is too fundamental a bulwark of liberty to be categorised simply as a rule of evidence applicable to judicial
Again,
proceedings.
talking specifically about
Yes.
self-incrimination privilege.
It's true. It's true. But, as part of the reasoning, which leads to the proposition on page 341. On page 341, they're on to say, in the second paragraph, there's a stronger reason for holding that the privilege is available in the case of an examination on oath before a judicial officer, which is a preliminary to a committal for trial or summary prosecution, than there is in the ordinary case where a statute imposes an obligation to answer questions, provide information or produce documents. On the other hand, the object of imposing the obligation is to enable, if the object of imposing the obligation is to enable an authority to ascertain whether an offence has been committed, then it is reasonable to conclude that the privilege, though inherently capable of applying, has been impliedly, if not expressly, excluded by statute. Then they're on to say, in light of the competing considerations, we're not prepared to hold that the privilege is inherently incapable of application in non-judicial proceedings. The issue of its availability in these proceedings therefore falls to be decided by reference to the statute itself. And then their honours refer to the common law, the principle of statutory interpretation that Your Honour would know as the legality principle. And they refer to it being engaged by taking away a common law right.
I'm sorry to keep harping on this, but we're still in the context of privilege against self-incrimination at this point, yes?
Well, in my submission, their honours are now dealing with penalty privilege because that is the very issue under consideration.
The privilege there,
yes.
You say, refers back to
yes.
the earlier discussion.
It has to be read with their description of 4 aspects of the privilege.
Okay.
So on the one hand, they've recognised that they have a distinct status, but they are referring to the privileges collectively in these passages.
The privilege, you say, refers back to discussion on 4 aspects of the privilege, yes?
Now they are dealing, I think it's fair to say, perhaps both with self-incrimination privilege and penalty privilege. I say that because, as Your Honour will see in a moment, they held that subsection 7 of 155 was partly surplusage. In other words, this reasoning is directed to holding that both self-incrimination privilege and penalty privilege were to be tested by reference to this common law, this principle of legality, and then by looking at the way in which the statute worked and what it was designed to achieve. And in the last paragraph of page 341, the Honour said that in deciding whether a statute impliedly excludes the privilege, much depends on the language and character of the provision. And
Sorry, can you just...
I'm sorry, Your Honour. Page 341, the last substantive paragraph.
Substantive paragraph, I've got it, yes.
In deciding whether a statute impliedly excludes the privilege, much depends on the language and character of the provision and the purpose which it's designed to achieve. Now, their honours then say, the privilege will be impliedly excluded if the obligation to answer, provide information or produce documents is expressed in general terms and it appears from the character and purpose of the provision that the obligation was not intended to be subject to any qualification. This is so when the object of imposing the obligation is to ensure the full investigation in the public interest of matters involving the possible commission of offences which lie peculiarly within the knowledge of persons who cannot reasonably be expected to make their knowledge available otherwise than under a statutory obligation.
Can I just ask you this? So with the exception of that little phrase, matters involving the possible commission of offences, doesn't that aptly describe the functions of a coroner's court? If you just insert in there the functions of a coroner rather than, involving the possible commission of offences, doesn't that aptly describe the object of imposing the obligation is to ensure the full investigation in the public interest of matters, and leave out that little phrase about possible offences, relating to the cause of death and all of the other matters that under, is it section 35 of the Coroners Act?
Yes. Well,
which lie peculiarly within the knowledge of persons who cannot reasonably be expected to make their knowledge available otherwise than under a statutory obligation. Isn't that an almost perfect description? Taking out that one phrase and inserting the objects of the Coroners Act under section 35, almost perfect description of the purpose of those provisions in the Coroners Act?
No, Your Honour. We would respectfully submit that, first of all, the words that Your Honour is excising are obviously very important to our argument,
Yes.
But it is quite a contestable proposition that in an inquest there will be matters which lie peculiarly within the knowledge of persons who can't reasonably be expected to make the knowledge available otherwise than under statutory obligation. Now, Your Honour might appreciate that that's a comment made in the abstract, but in the context of restrictive trade practices provisions of the Trade Practices Act, where these notices are in effect designed to uncover the existence of unlawful anti-competitive arrangements as an end in itself. And that is absolutely critical to our argument that where a statutory scheme is directed per se to the discovery of evidence leading to the proceedings to impose penalties for contraventions of the very law which confers the power, that is quite different from an inquest, which is obviously enough focused upon, for various reasons and steeped in history, including parts of history that are no longer relevant, like the fiscal relevance of inquests, which was once upon a time a significant feature of why inquests were carried out.
Sorry, Paddy, can you pass those tissues over, please? Can you?
But we would respectfully submit that the purpose of a coroner's investigation is not to uncover with a view to seeing dealt with criminal offences, much less civil penalties or disciplinary offences. It can be accepted that if and to the extent that notice of those matters incidentally arises in connection with an inquest, then they might form part of the broad subject matter into which the coroner is inquiring, but not as an end in and of itself. It remains incidental. That's our essential submission.
Yes, I think I've got that.
And I don't want to repeat myself, but Section 155 is really a power in the Trade Practices Act to discover contraventions of a civil character, a civil penalty character. Its very purpose was to enable the prosecution, and I'm using prosecution loosely because they were pecuniary penalties, and so that was why the High Court was moved, or the plurality were moved to say that really both incrimination privilege and penalty privilege were abrogated. Now, the later, there's lots of authority on authority in this case. Ironically, the later decision of Daniels Corporation would seem to pour cold water on the conclusion that self-incrimination privilege was impliedly excluded by that circumstance that I've just pointed to. I'll take your honour to that. But they held it was only expressly done away with by Section 155(7), which complicates things. But my point is that we would respectfully submit that if and when Your Honour is turning to the question of implied abrogation, broadly speaking, the kind of analysis that's engaged in at the bottom of page 341 is logical, and really it can't be disputed that it's, when one's looking at abrogation, one looks as part of that at the purpose of the powers.
Surely that's right, though. It is expressly taken away by Section 155(7).
Undoubtedly, but...
so where's the... I don't...
Yeah, well, only that the plurality in Pine Board held that even without 1557, self-incrimination privilege was abrogated. And that was...
So does that make all that obiter?
No, because it's part of the reasoning leading to why penalty privilege was impliedly abrogated.
Okay.
It is quite convoluted, I'm sorry, Your Honour.
No, it's all right.
Now, could I take Your Honour then to the very bottom of 342 and then on to 343? At the bottom of 342, that the privilege is impliedly excluded in such circumstances is a conclusion which may be more readily drawn where the obligation to answer questions or provide information does not form part of an examination on oath.
Right.
Now, this is my
You
subtle
rely on that
alternative.
for its opposite.
Yes, yes.
Sorry.
They go on, the obligation to give an answer not on oath at an executive inquiry provides an illustration. It will be less readily drawn in cases where the obligation to answer questions and produce documents is an element in an examination on oath before a judicial officer, and then I emphasise these words, whether or not an object of that examination is to ascertain whether an offence has been committed with a view to the institution of a prosecution for that offence. Now, what Their Honours are saying there is perhaps qualifying the general point that Your Honour was taking up with me at the bottom of 341, that although the purpose of the power is very important to the question of abrogation, and if the purpose is to discover the commission of an offence or a penalty provision more likely to be abrogated, at the top of 343, Their Honours seem to be saying, and we rely upon the proposition that has to be tempered where the obligation arises as an aspect of an examination on oath before a judicial officer, whether or not an object of that examination is to ascertain whether an offence has been committed with a view to the institution of a prosecution for that offence. Now, can I just, at the risk of confusing things further, mention at this point that whereas I think it was historically the case that under the Coroner's Act in this territory, and certainly if not in this territory, in other territories, a coroner could in effect commit a person for trial having regard to matters that have come out at an inquest. The Northern Territory 1993 Act doesn't go that far. The furthest it goes, and I think it's section 35(3), which speaks of a referral of a potential matter to the director. Now, I want to just briefly emphasise there that it's a referral to either the commissioner or the director if it's believed that an offence may have been committed. Now, this is a little subtle, but my point will be this, that to the extent that the Coroner's Act is really pursued at acting as an adjunct to the criminal justice system, it is in that very limited way. There is doesn't seem to be any equivalent provision that says, oh, and by the way, if you think a disciplinary proceeding should follow, make a similar referral. And Your Honour knows from my one other case before you that there are such provisions in other acts, for example, the ICAC Act, where matters can be referred for disciplinary purposes. Now, that's only a minor matter, but I just mention it now because it ties in with the sort of context that the High Court was talking about, where they were saying even if the judicial proceeding might result in an institution of a prosecution, it is less likely that the privilege would be abrogated. Now, the High Court the plurality don't spell out why, but our submission is that what's really being said is that it is an aspect of the operation of judicial officers administering oaths and sitting as courts that these privileges will be respected. We say it's a common law right, even if it's not a substantive law right that operates outside that context.
Would it be fair to say that the reasoning in Pine Board really all the way through hinged on the nature of the privilege against self-incrimination, and that penalty privilege kind of went along for the ride, and then the conclusion was drawn in relation to penalty privilege? Or is that too broad a brush?
If I can put it this way, I can see why Your Honour would say that, but we would say it's nevertheless clear that the High Court had from the outset considered them to be distinct privileges. So the court doesn't seem to have blindly assumed that the result for one must be the result for the other. They seem to have consciously reasoned in that fashion at two levels. One in saying that there's in effect a presumption that it applies unless abrogated, and secondly that the kind of analysis that you engage in to work out if it has been abrogated is very similar for the two. But it can diverge, and in my respectful submission, the case for abrogation of penalty privilege implied abrogation was all the stronger in Pine Board because the very object of section 155 was not discovering crimes, but discovering pecuniary penalties.
Civil penalty type.
So I accept what Your Honour says as a matter of observation, but we say that doesn't devalue the analysis for the purpose of our argument.
Yes, all right.
And now, just to round this out, at the bottom of page 343, Your Honour will see that having concluded that, in effect, both penalties were inconsistent with the nature of the statutory scheme, which wasn't a judicial proceeding, didn't involve an examination on oath, they said it could be said that the first part of subsection 7 was unnecessary. But the...
I'm sorry. Where's this?
I'm sorry, at the bottom of 343.
Understand? No. Is that what you're talking about?
Yes.
It's understandable that no similar provision is made in respect of the use of material obtained in proceedings for a civil penalty.
And the only proceeding of that kind which can be taken are proceedings under Part 4 of the Act, being proceedings in which the material obtained is intended to be admissible evidence. That's the point I've been trying to capture.
That makes sense.
And they say it may be, therefore, that the first part of subsection 7 is redundant. Strictly speaking, that is so. And then the court goes on to say why it might have been seen as a sensible statement for the avoidance of doubt. Now, finally, I should draw attention to a proposition which will be put against us at the bottom of 344.
Yes.
Attention should be drawn to the bizarre consequences of the appellant's construction. The privilege against self-incrimination would be excluded, but not the privilege against exposure to a civil penalty. True it is that the amount of a civil penalty under Part 4 is very substantial. Even so, it's irrational to suppose that Parliament contemplated that a person could be compelled to admit commission of a criminal offence yet be excused from admitting a contravention of the Act sounding in a civil penalty. Now, that argument is put against us on the question of if Section 38 is really just addressed to self-incrimination privilege. It's said, well, it's irrational to think that penalty privilege would survive, and I'll be developing a submission
Irrational,
about that.
bizarre, and I think there was another word, but yes.
There may well be. I think in another context, it's been said not very coherent about another statutory scheme. The short point we make about that really is that if the starting premise is the penalty privilege applies unless abrogated, we are not in a Section 155 type circumstance. Part of the reason why it would be so bizarre in Section 155 for self-incrimination privilege to be done away with but penalty privilege survive is the point already made, that the whole point of this is to discover contraventions that would give rise to penalties, not criminal offences. But more than that, we say this, Section 155(7) was a blanket abrogation of self-incrimination privilege. There was no discretion to be exercised by the Commissioner or whoever had issued the notice.
So no certificate provision.
Yes, but there's two elements to this. First of all, no option of preserving self-incrimination privilege. It just cannot be availed of at all. And because of that, a certificate, well, not a certificate, but a self-executing direct use immunity.
Unlike Section 38 and provisions of that nature, where it's at the discretion of the coroner
Yes.
whether to require the person to answer.
And so to anticipate my ultimate submission on this, it's really this. If you simply cannot rely on self-incrimination privilege at all, one can see why, subject to the context, it might seem bizarre that you can rely on a penalty privilege. But that is not...
Really, does the discretion make all that much difference?
Well, yes, because the coroner may very well decide that self-incrimination privilege should not be overridden, and the question will not be ordered to be answered. So, because it is quite possible that the coroner might conclude that the supposed criminality is peripheral to the true heartland of the inquest, or that there is other evidence such that it is just not necessary to have the person accuse themselves out of their own mouth.
Yes.
And because of the significance of the crime, if it were a serious crime, a certificate should not be offered. That is a very real prospect, we respectfully say. Now, if that's the case, it's not a foregone conclusion, it's not bizarre in our respectful submission that penalty privilege might simply exist in an untarnished form. We say that one could debate the wisdom of such a statutory policy, but it is not in the category of bizarre, and nor is it irrational. Of course, Your Honour, there are criminal offences and there are criminal offences. There might be many minor criminal offences where it wouldn't take much for a coroner to be persuaded, given the importance of the evidence to the inquest, that a certificate should be given. But we would respectfully submit that it is wrong to start the analysis of this case by assuming that self-incrimination privilege is more or less out the window. We say it's not. It's a very live question. And where it is out the window, to put it colloquially, it comes with a suite of protections. And that's the second layer to our argument. Now we say if privilege may or may not, if incrimination privilege may or may not disappear, but if it does, it comes with quite a broad immunity, is it to be implied that penalty privilege is out the window altogether with no immunity? Now, that might be a reason if you're on we say that's the reason why Naja's position should be rejected. Of course, if the Attorney General's position were preferred, then it's not quite so stark. But we say it is, what that argument illustrates is, it would be a very large implication to say there's this tailored potential abrogation of self-incrimination privilege that will invoke the interests of justice, a whole range of considerations, but if a certificate's issued, it'll come with all sorts of protections, to then say, well, by implication, you can't rely on penalty privilege at all, no matter how peripheral the issue might seem to the inquest, how serious the penalty, etc. So I'm perhaps jumping ahead, which will save me time later, but that's the argument I'll be putting.
I think I've got that. I'm just making a note, if you don't mind.
Thank you.
Thank you.
Could I just draw your attention very briefly to what Justice Brennan said at 355.
So can I just, before you do, it's past the time where we normally have the morning break, and I'm happy to go through if counsel are, but I just want to check with court staff too if anybody needs a break. You happy to go through? Are counsel content to simply go through and not take the morning break? All right.
Thank you.
Carry on.
Just briefly at 355, Justice Brennan, halfway down the page, I should just explain, Justice Brennan took a different approach to the plurality.
Yes.
He really asked the question which the full court in Kumanjayi say should be asked in all cases now: is the penalty privilege implied? So he put the onus really on the proponent of the privilege. But the reason I take Your Honour to his
Is it
reasoning
to
is that
construe?
in considering that question, he thought it was significant that if the context is not a judicial proceeding, well, how do you know whether the claim's a good one? He says at about the 10th line of that paragraph, in judicial proceedings, the validity of a claim of privilege is judicially decided. And he goes on to say, about 5 lines down below that, if it were in an investigation, how and by whom would the claim be decided? And then he says at the foot of that paragraph, neither of these solutions is likely to represent the intention of the legislature. Neither corresponds with the privilege which protects a witness in judicial proceedings, for that depends on the opinion of the judge. We would, obviously all of these statements are complicated by later authority, but the point is the one we would seek to rely upon if Your Honour's considering the statutory interpretation question, that the coroner is a local court judge. They can decide the question judicially. There are accepted practices that are applicable. It doesn't have any of the unsatisfactory features that Justice Brennan, at least, was worried about in an extra-curial context. And Justice Brennan continued in that vein on the following page, but I won't take Your Honour to that. I won't be as long with the other cases, Your Honour will be relieved to hear, but can I go briefly to Police Service Board against Morris, which is 1985, 156, Commonwealth Law Reports 397. In this case, 2 police officers had refused to obey an order that they answer questions when they'd been ordered by an inspector to do so, contrary to Regulation 95 A, sub 7 of some police regulations. The relevant provision in due course, Your Honour will find at page 402 in the Commonwealth Law Reports. So again, it was an entirely extra-curial context. At page 403, Chief Justice Gibbs commenced his analysis. At about point 3 on the page, Chief Justice Gibbs said, there's an obvious distinction. Does Your Honour see that?
Yes.
He goes on, nevertheless, although the penalties provided by Section 88 are disciplinary penalties, they're nonetheless penalties, and it's old law, confirmed by modern authority, that a person cannot be compelled to answer a question whenever the answer would tend to expose him to any kind of punishment. Then about 5 lines down, Chief Justice Gibbs said, moreover, it's now accepted that the privilege is capable of application in non-judicial proceedings, see Pine Board. Now,
Yes.
one issue is that in Daniels Corporation, this case is not referred to, which might only bear on whether it could be said to be seriously considered dicta. At the bottom of the page, Chief Justice Gibbs said, the 3rd line from the bottom, it is right to start with the assumption that the rule which confers the privilege is capable of applying to a statutory provision which requires members of the police force to answer questions.
Capable of applying doesn't necessarily mean will apply unless abrogated, does it?
I agree, but the next paragraph seems to suggest that on page 404.
Yes.
The question that then arises, and then His Honour uses the familiar express words on necessary implication. I agree, it is quite ambiguous, but it does seem to be.
But it goes on to
invoking the principle of legality.
Yes.
And then about 15 lines below that, there's a reference to Pine Board and the proposition that much depends on the language and character of the provision and the purpose which it's designed to achieve. Now, about 15 lines from the bottom of that very long paragraph, Chief Justice Gibbs makes a point similar to the point Justice Brennan made in Pine Board, that if penalty privilege applied in this police regulation, he says, if it were possible to claim the privilege, a difficulty would arise as to when and by whom, it should be decided whether the claim was properly made. Do you want to see that?
No.
I think it's 8 lines from the bottom. The sentence is starting 10 lines from the bottom. This view is
Yeah,
supported.
got it. Thank you.
So I just ask Your Honour to note that.
I see, yes.
Now, and at 405, at about point 5 of the page, he points to the fact that, again, if the penalty privilege applied, he says the determination of the question would be made by an unqualified person. It's a bit hard to pick up, but it's about 10 lines from the bottom.
10 lines from the bottom. In this paragraph that begins, it may be a matter for debate.
It's above that paragraph, about 12 lines from the bottom of that
Oh,
paragraph.
I see. The position will be different if the charge were heard by the board.
And a few lines above that, the determination would be made by an unqualified person.
Oh, got it. Yeah.
Now, all members of the court, I think, perhaps with the exception of Justice Murphy, who I think held that, didn't accept the premise of the argument, held that there was no room for privilege in the context of the disciplinary process. And I just want to draw your Honour's attention briefly to what Justices Wilson and Dawson said at 407, where in the second paragraph of their judgment, their Honour said, all questions of substance now fall for decision. The first is whether, and I just emphasise, the rule of the common law.
Yes, I see that.
Is capable of application.
The rule of the common law that a party is that which might tend to expose or the imposition of a penalty. So again, it's not analysed there as two separate privileges at all, isn't it? It's the rule.
Well, it could be looked at that way, or it could be looked at from the viewpoint that having recognised distinct privileges, they're saying each of the privileges is to be approached in this way. That's the approach we would contend for.
Yes.
And then over the page, the paragraph that commences the second question that arises is whether either the Act or the regulation reveal clearly, either by express words or necessary implication, a legislative intention, etc. So I just emphasise those propositions because although in a sense this could all be treated as a sideshow because it goes to ultimately to this question of whether in non-judicial contexts you start from a presumption and then consider whether there's been abrogation. What we would submit is that it is being, however far it travels, it is being referred to as a common law rule, which, where it applies, invokes the presumption or the legality principle. And we say that there is nothing in, well, there's not a skerrick of doubt in any of these decisions that in a judicial proceeding or whether there's an examination on oath, that the privilege presumptively applies, subject to...
But the coroner's ruling sort of went both ways, though, didn't it? Saying, well, the position is really, in her view, that that's wrong and that the statute has to impliedly confer the privilege.
Yes.
But then the rest of her analysis, the rest of the coroner's analysis was that, well, okay, based on the assumption that what you've said is correct, Section 38 does, by necessary implication, abrogate penalty privilege to the extent that is necessary to apply that certificate procedure.
I accept that, so I have to deal with the latter in any event, but I'm just saying that as between the two, pathways of analysis, we say Your Honour
Go
should
for the-
go for the second. And it may be that ultimately no other party disputes that, but there are some submissions that are put against us that I do think challenge the premise, and so we want to put those submissions.
But it won't really be necessary for me to decide which way it should go if it appears that the coroner was correct to say, well, even on the assumption that the privilege needed to be abrogated and the principle of legality applies and et cetera, well, by necessary implication it did.
Well,
I don't have to decide which way or which approach, do I? I mean, it's not necessary for this decision, which is a judicial review of the coroner's decision, for me to say, well, it's got to be either this or that.
Your Honour, it might be debated whether this is strictly a judicial review, because we are seeking declaratory relief.
Yes, all
the
right.
effect of which is that the ruling was wrong, but we're not in terms, we might not have standing to quash the ruling, and
No,
that isn't the way
we're seeking a declaration, yes.
So that's a technical, perhaps, nuance, but subject to how Your Honour resolves all these issues, I can accept that if Your Honour was against us, so if Your Honour said, even if I suppose that there's a presumption, I regard it as clear that it's abrogated.
Yes.
Then,
to the extent set out in section 38.
Then, whilst Your Honour could address the premise, I agree as a matter of necessity, Your Honour wouldn't need to. I think all parties would invite Your Honour, if Your Honour has come to that view, to at least say whether it's the Attorney General's position or NARJ's position.
Oh, well, that I think that is necessary.
Yes, because that will affect the future
Don't quibble
conduct.
with that.
Yes. Thank you, Your Honour. We're on the same page. Thank you. Now, can I come then to Daniels Corporation?
Yes.
Against the ACCC, 2002, 213 Commonwealth Law Reports 543.
Yes.
The High Court was back in the context.
Sorry, before you do, this is probably a convenient time to say so. I need to adjourn about 10 minutes early. I picked this at 12:30, so 12:20 rather than 12:30.
Thank you, Your Honour.
I picked this case up at the very last minute because Justice Brownhill was involved in a trial, and I have a prior appointment that I need to keep.
Thank you, Your Honour, and we're grateful for the court accommodating us. In Daniels Corporation, the court had to come back to section 155, but now in the context of legal professional privilege.
Yes.
As Your Honour well knows. And it was put by the ACCC that, well, the court in Pine Board held that penalty privilege and self-incrimination privilege were impliedly abrogated even without section 155(7), and what's good for the goose is good for the gander. Legal professional privilege is to be taken as impliedly abrogated as well. I mean, there could be no contention that it was expressly abrogated by 1557, and there didn't seem to be a foothold for privilege within the balance of section 155, at least in express terms. But the short holding is that legal professional privilege, being a substantive rule of law, must be expressly excluded, and that it wasn't. But incidentally, the plurality cast doubt on the proposition in Pine Board that there was an implied abrogation of self-incrimination privilege apart from section 155(7). In other words, that plank of the ACCC's argument was taken out from under the ACCC by the High Court saying, well, we're not so sure that the earlier court was right to hold that, yes, it's expressly abrogated, but not impliedly abrogated. That in turn peripherally raised whether penalty privilege was therefore back alive in the context of 1557, and in what I would respectfully submit is obiter, the High Court said, well, no, the result in Pine Board is correct. Penalty privilege is not available in section 155, but for different reasons.
Yes.
And one of the reasons alluded to, but not necessarily founded upon, was a real question about whether penalty privilege could operate in a non-judicial context. That's the short version of what was held in Daniel's Court. Can I just take Your Honour to some of the relevant paragraphs? I'm in the joint judgment. At paragraph 9, the High Court referred to it being settled law that legal professional privilege was a rule of substantive law.
Yes.
And then at paragraph 11, the High Court went further and said it's not merely a rule of substantive law, it's an important common law right, or perhaps a common law immunity. And the court said that important common law rights, privileges and immunities are not to be taken as abrogated unless the Potter and Minahan test has been passed. So that's, in a sense, nothing new. Paragraph 12, their honours noted that in Pine Board, all members of the court had treated as separate and distinct penalty privilege, in other words, separate and distinct from self-incrimination. In paragraph 13, they say that the privilege is one of a trilogy of privileges that bear some similarity with the privilege against self-incrimination, the other two being forfeiture and exposure to ecclesiastical censure.
What's that one?
Well, I think it was nearly as bad as self-incrimination once upon a time, but if one...
Does that mean you were going to get burned at the stake or something?
Well, I don't know about that, but maybe excommunicated or something of that nature. I'm straying outside my direct knowledge, but that's what I've assumed might be the and matrimony. Oh, and there's a matrimonial element to it.
I see, yes, in the old...
Yes. As I say, I'm straying beyond my knowledge there. I suppose the small
it has
point...
a nice ring to it, that's
Yes,
all.
it does. The point we make is that in what follows, when the High Court says, in effect, it's to be doubted whether it applies in a non-judicial context, it's nevertheless still describing this thing as a privilege. And noting in paragraph 13 that it was not just a rule of equity relating to discovery, and it had long been recognised by the common law. Now, paragraph 15.
Privilege against exposure to penalties is long, yes. Yes.
In paragraph 15, their honours referred to the passage in Pine Board where Acting Chief Justice Mason and Justices Wilson and Dawson had said they were not prepared to hold that the privilege is inherently incapable of application in non-judicial proceedings, pardon me, and said, however, that statement does not amount to a holding that the privilege is available in non-judicial proceedings. Later case, which I'll come to, admittedly only a single judge decision, I think Justice Blue of the Supreme Court has respectfully questioned whether that is correct.
Whether that analysis of the joint judgment is correct?
Yes, strictly speaking, because, well, I won't, I'll come to that judgment, but I just note it for the time being. And then in para 16, there's a reference on page 555 of the Commonwealth Law Reports to the rule concerning common law rights, and I emphasise common law rights.
Where's this?
Third line on page 555 of the CLR.
All right, got it. Thank you.
And
Yes.
somewhat confusingly, the court said that Justice Brennan's approach, which was to question whether privilege against self-incrimination or any like privilege could be implied into the Act, was an approach which failed to give effect to the rule expressed in Potter and Minahan.
Well, it does, doesn't it? It's the opposite.
Well, the reason I say confusingly, and I don't mean this disrespectfully, of course.
Because that's what they go on to
hold,
in a way.
In a sense, that's what the full federal court in Kumanjayi says.
Yes.
But I think part of the explanation is that, of course, Justice Brennan was dealing both with privilege and self-incrimination privilege.
Yes.
And it might be that the plurality here are saying, well, at least where the privilege is engaged, and there's no doubt that incrimination privilege was prima facie engaged.
Then
if it was engaged, then Justice Brennan didn't give the principle of legality enough work to do.
Yes.
It might be said they're silent as to whether that was a necessary approach in relation to penalty privilege, because as you'll see in a minute, they cast doubt upon whether in a non-judicial context there was even an occasion to consider the legality principle.
Yes. Gracious.
Yes. Then at the bottom of that page, in paragraph 18, about 7 or 8 lines in, the joint judgment turned to what was said by the joint judgment in Pine Board, noting that the effect of it was that the first part of subsection 7 was redundant. Now, I mention that because that's later a separate basis for criticising the finding in Pine Board. If Your Honour would then please come to paragraph 23. It was argued by the ACCC, as I've already told Your Honour, that section 155 should be construed using the same process as was adopted in Pine Board. And to recapitulate, if penalty and self-incrimination privilege are impliedly abrogated, even without 1557,
yes,
then so too legal professional privilege. And essentially the High Court said, no, we're not going to proceed by parity of reasoning, and there are numerous reasons why we're not going to. And one of them, perhaps the most obvious in paragraph 24, is that there just doesn't seem to be such a difficulty with privilege being able to be claimed in response to a 155 notice, because if the legal advice or communication relates to something unlawful or illegal, the privilege won't be available anyway. So in a sense that could have been the short answer, but the High Court go on and express other criticisms of the reasoning in Pine Board. And so at 25, when they say there's a number of difficulties with applying Pine Board, one of which has already been mentioned, namely that the approach adopted by Justice Brennan was inconsistent with Potter and Minahan. There are also difficulties with the approach adopted by Acting Chief Justice Mason, Wilson and Dawson. The chief difficulty, Their Honour said at para 26, was that they'd overlooked some other provisions of the telecommunications legislation that were engaged by section 155. We don't need to worry about that. The next matter in paragraph 27 was that it had been held in a later case of Baker and Campbell that legal professional privilege attached to a provision of the Crimes Act that was very similar to 155. And then at 28, we come to the point that's relevant to Your Honour's determination. It was said that the other difficulty with the approach was that, as already noted, it rendered the express abrogation in 1557 of the privilege OTOs, and that was contrary to a general maxim of statutory construction. Then at 29, Their Honours said, given the difficulties, that the approach of, in effect, applying by parity of reasoning Pine Board should not be followed. Their Honours then said, so to say is not to say that Pine Board was wrongly decided.
Yes.
Then we would submit respectfully that what follows here is obiter. Now, I don't think anyone disputes that. The only question is it seriously considered dicta? The court said at 30, the implication that the privilege against exposure to penalties was abrogated can be supported by reference to the absurdity that would result. So in effect, the very last reason given in Pine Board would be a sufficient reason to reason that because self-incrimination privilege was expressly abrogated, penalty privilege should have been impliedly abrogated. And again, that passage is relied upon against us, and our response is the response I gave Your Honour earlier, that it's a very different case where there is not a complete abrogation and there is a qualified abrogation coupled with a protection. Then at paragraph 31, there's a further passage that's relevant, and after the quote from Naismith and McGovern, the High Court said, today the privilege against exposure to penalties serves the purpose of ensuring that those who allege criminality or other illegal conduct should prove it. I'll come back to this, but can I ask Your Honour to note the footnote is to ABCO, a decision I'm going to take you to in a minute.
Yes.
However, there seems little, if any, reason why that privilege should be recognised outside judicial proceedings. Certainly no decision of this court says it should be so recognised, much less that it's a substantive rule of law. Just pausing there, it might be debated whether Morris says it should be recognised, but against what I've just said, in the end, Morris held that penalty privilege was not available, but had arguably started from a premise of it needed to be abrogated.
Unless abrogated.
But it may be that Morris wasn't cited, or it might be that the High Court accepted Morris but said, well, nevertheless, it's not a holding that the privilege does apply, it's a holding that it doesn't. And how the court got there is neither here nor there. But further, Their Honour said it should now be accepted that as the privilege against self-incrimination is not available to corporations, nor is the penalty privilege. So the decision in EPA and Caltex was a further reason why Pine Board was correct, but maybe not, Their Honour said, for the reasons given. Now, this passage is very important because in Frutigny, the full federal court analysed it and a later decision of Rich, and on one reading of some paragraphs in Frutigny, suggests that even in a judicial proceeding, the privilege is only available where there is a penalty being sought in the very proceeding.
And that's a reference back to the origin of the privilege of being in proceedings for a penalty where discovery and interrogatories are not available.
Your Honour's quite right. Respectfully, we say that hits the nail on the head. It might be a reference back to the origin, but it's not a description of its scope. And the reason that's clear, well, we say, we respectfully submit, is that one of the cases cited is ABCO, and ABCO couldn't be clearer than that the privilege is available in a context where the penalty is not being sought in a proceeding. But the procedure that's adopted differs, and that takes us back to Justice Dean in refrigerated Australasia. Where the penalty is being sought in the proceeding, there's an absolute embargo on discovery. There won't be an order for discovery, and nor could there be a compulsion to give oral evidence. But where the penalty is not sought in the proceeding, it's a document by document, or we would say question by question approach to the availability of the privilege. And can I just take Your Honour to ABCO to make that plain?
Okay, that makes perfect sense.
Thank you.
So ABCO, you say?
And just before Your Honour goes there, please note that the passage from ABCO that's being referred to is 129. For the transcript, I'll give the reference of the case. Trade Practices Commission against ABCO, that's with the double B, Iceworks Proprietary Limited, 1994, 52 FCR 96 at page 129. If I can say so with respect, Justice Birchett's decision is a masterpiece of legal history and analysis, but attention can be confined to pages 127 to 129 of ABCO. This was actually a decision of 5 Federal Court justices. But at 127, at about paragraph F, does Your Honour see that?
Yes.
The true rule is not based on a categorisation of the action as an action brought by a common informer, or even as an action brought solely to recover a penalty, although it does apply in such cases. It is a false syllogism to see the rule as therefore restricted to these cases. Reference is made to Naismith, which is the very case the High Court had cited in Daniel's court. And then at G, that was not to put the matter on the basis of some narrow principle applicable to actions for penalties or forfeitures, but on the broad principle of equity, which Lord Harwick applied in Smith and Reed when he said there's no more established rule, etc. And I won't read it verbatim.
Got it.
But then on page 128 at letter B, the point was put very clearly by Lord Justice Lindley in Martin and Treacher, where his judgment proceeds not on the basis of a rule peculiar to actions for penalties, but upon a consideration of how the well-established principles of law with regard to discovery apply to such a case. Now, in other words, it's not dependent on there being a penalty in issue. Then at letter D, there's a reference to a judgment of Justice Isaacs in the High Court in Associated Northern Collieries, where in the very last part of the passage of Justice Isaacs, something very similar to what Justice Dean said is set out. I'll just read the last sentence. In the former case, there is no such necessary consequence, and whether the objectionable tendency exists or not has to be otherwise ascertained, and claiming immunity upon oath in the course of making discovery is the most usual, but not the only means of establishing it. In other words, Justice Isaacs is saying, if the proceeding's not seeking a penalty, and that's the former case, it's not necessarily the fact that there'll be a exposure to penalty. You'll have to establish it
On a
item
by
item
case
basis.
question by question basis.
And so at letter G, Justice Birchett says, in this passage, Justice Isaacs assumes there's a single principle, and he refers to the objectionable tendency, in quotes. Then coming over the page to page 129, the page cited by the High Court in Daniel's Corporation, second line, there's no suggestion here, nor is there elsewhere in the detailed judgment delivered by Justice Isaacs, that the exclusion of discovery in actions for a penalty rests upon some principle peculiar to such actions, and not upon the principle applicable to any discovery that has the tendency to self-incrimination or self-exposure to a penalty. And then the reference is made to Justice Dean's judgment in refrigerated express lines and letters C, D and E Justice Birchett in effect emphasises the importance of the principle and says that whilst it's distinct from self-incrimination privilege, and he says at letter D, the principle may evoke less feeling, but it remains the same principle. It's wrong to regard the two grounds or aspects of privileges depending on unrelated or different considerations. Should not be seen as separate props in the structure of justice, rather they're as interlocking parts of a single column. Now, I should have said the whole point of ABCO was to consider whether penalty privilege was available to companies, and part of Justice Birchett's analysis was to tie it back to, in effect, the fundamental principle of a person having to accuse themselves. And after analysing all of these matters of the scope, His Honour found that penalty privilege was not available to companies. But the point we would wish to emphasise respectfully is that it's very clear in the judicial context that it's not limited to proceedings for the imposition of a penalty, and the High Court should not be taken in Daniels Corporation to be impliedly disapproving of the very passages that they in fact recite. Now, I'm getting there, Your Honour. If I can come to Rich. Rich against ASIC, 2004, 220 Commonwealth Law Reports 129. This was obviously an action.
Trying to find it in your. Got it.
An action by ASIC against company directors, and the real question was whether, because disqualification was one of the grounds of relief sought, and that followed upon breach of something called a civil penalty provision, as distinct from a pecuniary penalty provision, whether that was a penalty that invoked the concept of penalty privilege. In my respectful submission, that context is important because with respect to the full federal court in Frutigny, we would respectfully submit that in some obiter passages in Frutigny, the full court misapprehended what was really an issue in Rich. Now, this was a case where the question was whether the parties should be relieved from basic rules like discovery in limine. And the only suggestion, so far as I can see from my reading of the case, of any penalty that the parties could be exposed to was the very relief being sought in the action, namely disqualification. And so the reason why the High Court was considering whether civil penalty provisions leading to disqualification invoked the privilege was not because it had to be a penalty sought in the very proceeding, but rather that was the only penalty that was on the cards. And the question was simply, is it a penalty?
Yes.
And very briefly, that's apparent from paragraphs 19 and 20 of the joint judgment, where it is assumed that because it's a curial, well, my submission is it's assumed that because it's a curial proceeding, the penalty privilege will be engaged if there's a penalty on the cards. Indeed, section 1317L positively required the evidence and procedure for civil matters to be applied, and the High Court said that positively required the relevant doctrine to be applied, and the court said at the bottom of 19, in the course of oral argument in this court, its counsel affirmed that it was not argued that such privilege as there may be has been abrogated.
It was simply a question of whether the privilege applied to that particular penalty, whether it was a penalty.
That's our submission, and that's then if Your Honour comes to 23, the court dealt with Daniels Corporation and what it had said about penalty privilege being one of the recognised privileges at para 24, reference to what was said in Daniels Corp. In effect, then at the end of 24, in the present matter, however, the only issue is about the application of these privileges to discovery and judicial proceedings. No wider question arises. So, in effect, harking back to what Daniels Corporation had said in the non-judicial context, the High Court was really saying, well, we don't have to worry about any of that. And then at 25, there's no question of abrogation. And then at the very end of 25, which is on page 143, there's a sentence that starts, thus the question in the present matter becomes whether the privileges against exposure to penalties or forfeitures are engaged. Do the proceedings expose the appellants to penalties or forfeitures?
I'm sorry.
Sorry, it's the last part of 25. And it's,
Got it.
now, in my respectful submission, it may be that, with great respect, the full federal court has elevated that passage into meaning that the starting point, even in judicial proceedings, is to see whether penal privilege is engaged, instead of, is this a penalty?
This one, yes.
And we say that Rich, therefore, doesn't really add to or change the submissions we've put to this point. That brings me to the full federal court in Frutigny. That's 2018, 259, Federal Court Reports 219. The question here was whether in proceedings in the Administrative Appeals Tribunal, penalty privilege could be relied upon to, in effect, defer certain procedural obligations such as pleadings or witness statements. The full federal court were quite explicit in saying at paragraph 7, in the fourth line, while this court has been invited by MARA to determine the wider question of whether penalty privilege applies at all outside purely judicial proceedings as a pathway to determining whether the primary judge had erred, it's best that this appeal is not determined on any basis wider than it needs to be. That limited approach avoids traversing decisions of non-federal intermediate appeal courts dealing with this issue in the context of non-federal tribunals, which have a very different legislative and constitutional context and may have a judicial character of a kind that cannot exist in the federal arena. And then in the last sentence, this court does not need to go beyond determining the application of penalty privilege to these particular AAT proceedings and accordingly should not do so. We say that is important in understanding the ratio as distinct from the obiter in Frutigny. In effect, their Honours were saying, we're not even deciding generally what the position is in executive type non-judicial proceedings, much less are they dealing with judicial proceedings. Nevertheless, and I say this with great respect, there are passages that do go outside of that area and as a result give rise to obiter observations that other parties are, other interveners are urging that Your Honour should follow. Now, if I just give Your Honour perhaps the references. At para 9, there's a reference to the concept of seriously considered dicta. In para 10, the court says, therefore, we might need to determine whether Daniels Corp is seriously considered, but then on about the 6th line, the court says, even if such a comment cannot be regarded as seriously considered dicta so as to fall directly within FARA, the safest and soundest approach is to take it at face value and endeavour to give effect to it. Now, then commences a very detailed analysis of all of the cases that I've just taken Your Honour through, and I won't repeat the task. But if I could come to 32. At paragraph 32, the court says, the later decisions of the High Court of Daniels and Rich, which are discussed below, go further in casting doubt on the correctness of the implicit assumption in Morris that penalty privilege is akin to the privilege against self-incrimination and is capable of applying to a non-curial proceeding unless statutory construction leads to a different conclusion. While the view taken in Pine Board has been accepted to the extent that penalty privilege, like the privilege against self-incrimination, was considered to be a common law right, both Daniel and Rich contain clear indications, albeit obiter, that the scope for the application and their essential nature is not the same. Now, we respectfully say that even if that is accepted in total, it is acknowledged that it remains a common law right, but just that it is different and doesn't apply as widely, it doesn't presumptively apply as widely as self-incrimination privilege. Now, there are then deal with Daniels Corp, and at 39, again, I emphasise in about the 8th or 9th line, while penalty privilege and the privilege against self-incrimination are both rules of the common law, penalty privilege is not a substantive rule of law. So again, we say it's at least accepted that it is a common law rule. Then in Rich, in the analysis of Rich, I don't want to labour this, but at paragraph 42, the court said that the joint judgment in Rich confirmed that the relevant approach is not one of determining whether there's been a statutory abrogation. Rather, the question is whether such privilege is engaged in the first place.
You say that's wrong because the issue in Rich was simply whether this was in fact a penalty.
Respectfully, that's a submission. Now, it doesn't infect. I'm not for a minute suggesting the outcome in Kumanjayi is wrong, but we say that too much status has been given to what was dealt with in Rich. And then there's reference to, at 44, to observations by Justice Kirby in dissent. Then there's a section headed Reconciling Pine Board, Sorby, Morris, Daniels and Rich that starts at 45. And it really culminates in a proposition at paragraph perhaps if I'll invite you on to read all of this in due course, but perhaps at 51, if I can focus there.
I have read this case
Oh,
just to
yes, sorry.
know, but I'm carefully marking the parts that you
Yes, thank you. Well, I'll be a bit more,
rely on.
I'll be a bit more selective in what I take
I'm not
currently.
trying to stop you in any way.
No. At 51, Morris reasoning must now give way to Daniels and Rich reasoning. And then in the FCR, it's at the top of page 235, penalty privilege ordinarily applies only in a curial setting to protect a party from having to assist in the process of seeking to have a penalty imposed upon them, but may be found to have a broader application as a matter of statutory construction. Now, to the extent that that's saying...
Do you quibble with that?
It just depends whether it's...
May be found to have a broader application as a matter of statutory construction,
Well,
including by reference to curial features of an otherwise non-curial setting. Well, you've been saying something similar, really, when you're pointing to the importance of there being, for example, examination on oath
Yes.
before a judicial officer as being curial features of an otherwise perhaps non-curial
Yes.
setting.
We do embrace that aspect of it, and it's perhaps unclear how far the sentence goes, but if it's suggesting that in a curial setting, unless there's a penalty on the cards in that particular proceeding, you need to look for a basis for implication as opposed to a basis for abrogation, we would respectfully submit, we would quibble with that. And at 51 is a bit ambiguous on its...
Not really necessarily saying that.
No, I agree with Your Honour, but then when we come to paragraph 77, the court does seem to go a little further by saying that following Sorby, the starting point for the privilege is that it exists and applies unless abrogated. But that's not the starting point for penalty privilege following Daniels and Rich. And then in each setting where penalty privilege is claimed, the opening question is whether the privilege applies in the first place, not whether it has been abrogated. Now, that would appear, and if it doesn't mean what I'm worried about, then so much the better, but it appears to...
It doesn't appear to be confined to non-curial
Yes,
proceedings.
That's the point.
On its face.
And then at 79, there seems to be a more open textured test, which is that really that it's never presumptively available. You've got to look at whether it's a curial proceeding, whether the proceedings expose the claimant to penalties or forfeiture, and whether it's been, well, I won't read out 3. We really just say that those observations aren't necessary. That they may well be absolutely apposite, in the context of the AAT, but we say shouldn't guide Your Honour if Your Honour accepts one of our premises, which is that the coronial inquest isn't a purely executive inquiry and has significant curial features to it. So I won't read 81, but that is in the same vein. Now, lastly, I want to go to, I hope to be able to conclude this before 12:20, but please stop me if I waffle. The decision of Justice Blue in Bell and Deputy Coroner, 2020, 138, South Australian State Reports at 467. Your Honour can see in the head note on the second page of the report, section 3 of the South Australian Coroners Act as it stood at the time, and relevantly the coroner could require someone to answer a question at an inquest. Under subsection 5, they were not required to answer the question or produce a document if A, incrimination, B, legal professional privilege. Now, in some respects, therefore...
It's an absolute
non-abrogation.
Yes.
And in some
It's an absolute preservation. It's not a partial abrogation.
yes, but and the question was, is it only a partial preservation? Therefore, is it implicitly a partial abrogation?
Good Lord.
In a sense, it's a bit similar to the position that applied under our Act before 2002, because before 2002, you had Section 38 preserving incrimination privilege, didn't have the legal professional privilege provision, but we would obviously submit that following Daniel's Court, it just lives there unless the plainest language excludes it, and so that legal professional privilege must be available in an inquest. So this is the closest we get to a decision that ties all of this complexity together, and we rely on it in various ways. The argument, just putting it very briefly, was the coroner ruled that penalty privilege couldn't be relied upon, in effect saying, well, look, the Act is quite clear, it preserves legal professional privilege, self-incrimination privilege, but impliedly, by not mentioning penalty privilege, that's gone, or it was never there. Now, Justice Blue rejected that argument. The holding is that penalty privilege remained available. We respectfully urge upon Your Honour the technique that he deployed to get there, because we suggest that it's applicable here. Can I take you on to paragraph 103?
Yes.
Just to point out some similarities and some differences with the current Act that we're dealing with. First, you'll note, Your Honour, that the South Australian Act actually established a court and said it was a court of record. That is not the case in the Territory, but I'll take Your Honour to authority that we would respectfully submit has the result that there is a court of record.
Mr. Doyle, I'm sorry, I am going to.
Yes.
Firstly, I don't want to hurry you up, so that if you're going to take, time to do this, you should be able to do it without racing the clock to 2:20, and second, 12:20. Secondly, it's 12:19.
Thank
So,
you.
I will adjourn
Thank you.
now, if that's whether or not it's convenient. Please adjourn the court. Thank you.
Journalist,
Two. Yeah. That's what
that one.
Yep.
Understand everything there, look, I bet you did. It's all really straightforward.
Sound on that, isn't it? If you beat into the set,
He's got like a word of this,
Down
and talk to
tools.
the journos and all the springs going.
it's better for me, so because I can get distracted by that.
Oh, this one, particularly complex.
Give me a mark and a pen. First name?
Emrys, E-M, just one M.
Got it.
R-Y-S.
This name?
No, here, let me do it.
Yeah.
Not that I'm inviting.
Yeah, the self-correcting elements are pain. Not for the capital
There we go.
Sending that down to the journos and Alice.
Oh, okay, there we go. That's it.
Oh, really?
Yeah, that's my surname.
Got it.
It's Czech. Ne uphill means the one who didn't hurry.
Oh, nice work. That's the story of my life, unfortunately.
Yeah, I'm just double checking what time with Darwin Court. Yeah, it's usually 2, but just calling to double check. Okay, if there is an email sent, could you forward it on to me? Beautiful, thank you so much. Okay, fine. Yeah, they don't know yet. I'm assuming 2 o'clock, but
Council, Her Honour's appointment's running a little bit late, so we might be another 10 minutes.
Whereabouts are you staying up here?
The 5.
Okay.
It's good, yeah. When I was here in August, it was posted James Rennie from Sydney, and yeah, he recommended it. So it's got a nice, very,
At the Hilton.
oh yeah, okay. You come up here much?
Not a great deal. Probably have 2 cases up here before this.
Yeah, same.
Yeah. It's good place to work, actually.
Yeah.
Community and facilities and all of them.
Up here, that's invited me to the legal battle of the bands.
Oh, right.
Which is fabulous. So classic. Darwin institution. It's sort of the whole of the territory, isn't it? It's quite similar.
Yes, Russell Goldflame came up. The musicians came up from it.
Oh, I see, yeah, but the serious competitors. Right? Yeah.
Can they say no?
Great. It was a really nice vibe. It was there.
They can't see the bar table.
DPP won in the end.
Oh.
Boys abstained.
What was their winning number?
Our side.
No, I can't remember, but I think his wife's like a professional.
Should be appearing.
Close to the edge.
Do you want me to call them again?
Does anyone ever
Like we dial them again?
litigations in respect to battle of the bands?
Oh.
You could just get a go-to sitting there to hear. Convene a court.
Because see, Alice Springs can see this.
Oh, it's just so nice to Oh, that's all right. Some complimentary things about just really enjoying sitting out in the morning. I don't know what's been like. It's been miserable. Yeah, it's just been so cold.
It's just only a thing.
Yeah.
I didn't get anything from Alice Springs vacancy. So I participate in this group, whatever party I do.
Tomorrow evening.
I'll just maybe ask associate if you
No, it's not 10 morning.
But if they want, we can call them. Wait for associate. We can redial again so that. Yeah. Just tell them if they want, we can redial them again.
I'll go back to the hotel and sleep. Mine's at 1.
Safety nets.
Yeah.
Probably all right.
Yeah. I'm actually going from here to Brisbane. Yeah, it's judgment on Friday. Brisbane's not on
Swing vibes. Collect a win. It's a loss, just.
Yeah, exactly. But yeah, it's just so nice to be
Because he said it's from the morning, it's not now.
Okay, sure. Yeah. What's your Brisbane?
really interesting. Here it's about online. Yeah, it's like the hot holdings machine installed. Distinct.
Mr. Game, can you see the bar table now or no?
It was there before, but now we can't see it.
Okay, did you want to try and end your connection and rejoin?
Yeah, so we can see half of Alice Springs and the judge, but we used to, a little while ago, for the first time, see the judge Darwin Court.
Right.
But now we can just see the judge and not the Darwin Court.
Right. If you could just hang up from your end and try and rejoin, I think that might.
I don't know how to do that though. Are you just gonna?
We'll do that.
They will call you. You accept.
It's pretty good having all those facilities, but can't see the bar table for some reason. Just getting a sort of one-way video link was a big deal. Oh, yeah. The federal court maybe. Oh, yeah. You'd be half expected to travel Melbourne for a 15-minute hearing.
Exactly.
Quite scandalous when you think of the way.
Yeah. It's ridiculous, especially people flying in from 3 states. Yeah.
It almost creates a bit of a brawl because you figure if we're going over there, once we're over,
Exactly, yeah, exactly. I'm going to justify the trip. Yeah, it's history.
Actually, no, the people
It's interesting. I feel like the court is finding their level now. You know, like going to Perth.
Thanks.
The applicant wanted to go, so we'll go. But then I kind of think, well, just all do it by teams.
Yeah.
You know.
Horses.
But yeah, we sort of proved you can do it. Way in Victoria. Long time ago. Administration justice.
Good things to be achieved.
Did you get locked down for long?
Mr. Boyle, can I confirm whether you can see the bar table in Darwin?
Yes, I can.
Okay, great.
The court's up.
They went on to charge only. There are lots of directions hearings, but
because we know more or less where we are.
I'm loving the Boyle and Doyle. It's really.
I was laughing because one of my
Mr. Boyle and others in the Teams meeting, I think what I'll do is just make a new link. So I'll cut this one and make a new link. Oh, here we go. Hang on. Just see.
the later edition.
I've got the right, okay. Struck through.
Is that any better, Mr. Game?
No.
No. Okay. I'll cut this link and I'll make a new link and hopefully that works. And I'll send you fresh invites.
Thank you.
Right.
I was junior, but
Yeah, you've got to get the link correct.
yeah.
Okay, because if you type my surname to Jay.
Only do it again. Or it's from your end.
No,
So I had this one absolutely tragic loss, like just got completely demolished. And my name is spelled Nickelapilly.
oh, brilliant.
So I think I'll just leave that way.
Hang up the Teams.
Should actually make a habit of misspelling it and then correcting it if I win.
Yeah, that's great.
The record. Got to should you into the year?
Sort of moderate. Not a few, I think 2 appeals. Mediation. Mostly. I'm supposed to be in a trial throughout this month, which we're doing that sort of metro. Take on random things like this, which is good.
Yeah.
Looking to get clogged up for a moment. I didn't.
I've been Teams.
Yep. Yeah, and then
Teams.
Yeah.
it pops up.
Yeah.
Yeah.
Nice.
Hey, Stace. No. Sweet. Thanks. Yep.
Please enter the conference ID, followed by the pound or hash key.
39 446.
Please hold while I try to connect you.
Is that okay, Mr. Game?
Yes, except now we can't see the judge.
Oh, there you
Now we don't. Yes, now we can see the judge.
You can see the judge?
We
Yeah,
see
that's
everybody. That's good.
Okay, great. We'll get started.
Thank you.
Resume back now. Silence all stand. This honourable court is now in session. Please be seated.
Yes.
The court pleases.
Mr Doyle.
Before we adjourned, I was addressing Your Honour on the decision of Bell, at paragraph 103.
Can I just ask for, before we start, a quick estimate about how long you think you will be so that we can...
I think I'll be about an hour and a quarter, and I've spoken to Mr Boyle and he doesn't expect to be terribly long at all.
All right, okay, thank you. But that gives us...
I might be able to come in under that, Your Honour.
Okay. I'm just thinking of the time we've got allotted.
Yes.
But
yes,
you go
I'm
ahead.
certainly mindful of that. At paragraph 103, and following, Justice Blue described the South Australian scheme. He mentioned that the court is a court of record. I'll come back to that in a moment in the Northern Territory context. At paragraph 109, pardon me, at 107, His Honour set out section 21. Could I draw to Your Honour's attention that in South Australia, the coroner must hold an inquest where there's a death in custody, which is one of the features as well of the Northern Territory scheme that emphasis is placed upon by the interveners. So that was also the case in this decision. Section 22 contains the compulsive powers. They're set out at paragraph 108. At paragraph 109, the critical section 23, is set out, and I've already addressed Your Honour on the basic structure of that section, preserving expressly as it did privilege, incrimination and legal professional privilege. At 111, His Honour set out section 24, court's not bound by the rules of evidence. That is a direct analogue of section 39. At paragraph 112, His Honour set out section 25, which deals with findings on inquest and is broadly similar to the Northern Territory provisions, although not precisely so. Now, then, if I could ask Your Honour to come forward to paragraph 132, where His Honour commences to consider the availability of penalty privilege. His Honour dealt with the authorities that I've already addressed you on in a series of paragraphs through to about paragraph 149. And at paragraph 149, His Honour indicated that it was common ground in the present case that penalty privilege can be claimed in a curial proceeding, notwithstanding that the penalty could not be imposed in those proceedings, but might be imposed in different proceedings. That was the point I was labouring earlier today, but I wanted to lay the foundation for that. Your Honour will see footnote 47 includes the refrigerated express case and the ABCO decision, amongst others. In our written submissions, we have provided further authorities for that proposition in our footnote 41, but I won't take Your Honour to them now. At paragraph 150, His Honour describes the principles applicable in a curial context, and I don't need to go to those given that all parties are accepting the issue is live and not moot in the present case. Then at paragraph 151, His Honour commenced to consider, referred to the question whether penalty privilege was available in a non-curial context, noting that the parties had made submissions about that. But at 154, His Honour said it was ultimately accepted that it wasn't necessary for him to decide the question of the availability of penalty privilege in, for example, disciplinary proceedings, and he did not do so. But he, because the parties had made submissions about it, he did make some observations between paragraph 156 through to 160, where he dealt with the cases that I've addressed Your Honour on. He then came to Frutigny at 161 and set out one of the passages I read to Your Honour earlier today, and then at 162 said the passage extracted above constituted obiter because the full court had earlier said that its decision was to be regarded as confined, and we respectfully adopt and urge that approach upon you. At paragraph 163, he referred to an obvious tension between Pineboard, Sorby, Morris on the one hand and Daniels on the other, but said he didn't need to decide the issue. But he nevertheless went on to apply the principle of legality as to the availability of penalty privilege in the curial context of the coroner's court. And we say that that is the approach that Your Honour can and should take in this case. In considering that question, at paragraph 164, Justice Blue set out how the coroner had approached the matter, and the coroner had, much in the manner of the Frutignier decision, said one does not look to see what personal privileges have been excluded. One looks to see what excuses have been made available for non-compliance. Justice Blue said at 165 that, and this is on page 498 of the report, I consider that it is erroneous because it takes the approach adopted by Justice Brennan rather than the approach adopted by the plurality in Pineboard. His Honour then approached the question of abrogation by reference to the familiar statutory interpretation principles of text, context and purpose. So at 167, he looked at the text. He said it's not expressed to include it. At 168, he adverted to the argument that I've already addressed with Your Honour that comes from Pineboard and Daniels, that if Section 23 had abrogated self-incrimination and legal professional privilege, he says an argument would be available that it was implicit that penalty and forfeiture privilege were also abrogated. He didn't need to resolve how that argument would play out, but what he was contemplating was seemingly a complete abrogation in the nature of the abrogation in Pineboard. We accept, obviously, that that's a relevant consideration for Your Honour, but we say Justice Blue isn't to be taken as suggesting that that would be decisive. At 169, His Honour said that really the argument for the Attorney General in Bell was that when the statute preserved legal professional and self-incrimination privilege, it was covering the field. And at 170, His Honour said covering the field type arguments aren't good enough for the purposes of the principle of legality. It would need to be done expressly, is effectively what he said at 171. He also pointed at paragraph 172 to the difficulty that arose from the state's contention in that case that whilst they were submitting that penalty privilege was abrogated, it was being suggested that other privileges and immunities, such as public interest immunity, might continue to apply. And Justice Blue said, really, you're urging upon me a mishmash of preservation and abrogation, and in light of the principle of legality, I'm not prepared to proceed on that basis. And so we would adopt and seek to apply that sort of rationale to the present case. When I make these submissions, I'm really addressing two different things. One is the position before 2002, which we say is very similar to Bell. And then when we step forward to 2002, the same interpretative techniques apply, but obviously we have the new Section 38 to contend with. Can I come then to context at para 178? At para 178, His Honour said that there was nothing in the context that pointed to abrogation of common law privileges, apart from two. His Honour pointed out that Section 23 didn't create an offence of failing to answer a question or produce a document, and said the fact that the section adopts the common law procedure and sanction of contempt is consistent with a lack of intention on the part of Parliament to abrogate common law privileges. That there's some
tenuous, isn't it?
Pardon me?
It's a bit tenuous, isn't it?
Well, it's probably marginal, but I think His Honour's dealing with contextual matters.
All right.
Para 179, however, we would place greater reliance on, that where you have a court, it's a common law concept, and the fact that Parliament chose to create the court as a court and that courts traditionally recognise common law privileges is consistent with a lack of intention to abrogate. Can I just ask you to note in this context that we rely in particular on Section 6.2 of the 1993 Act, which preserves the common law powers and duties of a coroner. At paragraph 180 and so on, His Honour dealt with matters of legislative history. At 183, His Honour referred to a predecessor provision that had just referred to the concept of tending to incriminate without specifying more than that, but His Honour said that that sort of language was indicative of the self-incrimination privilege rather than the penalty privilege. That might have some marginal relevance to Your Honour in relation to Section 38. Then His Honour dealt with mischief in paragraph 186, noting that although the second reading speech had only referred to the preservation of the right of self-incrimination, right against self-incrimination, at 187, His Honour said that although no reference was made to any other privilege, including legal professional privilege, that is at best neutral for the state. Then at paragraph 190, His Honour said that the state contended that penalty privilege had a lower status, and His Honour rejected that proposition, at least rejected it in the way it was put, saying that a penalty subject to penalty privilege may have a far greater consequence, depending on the facts, such as a dismissal from office, than a penalty imposed for an offence protected by self-incrimination. At para 191, His Honour rejected the proposition that simply because the court is not adjudicating rights and liabilities, that tended towards abrogation of privileges. Again, we would...
You can take it, I have read this case.
Thank you, Your Honour.
But if there are important points you want to draw out of it, you know, I mean, don't feel constrained.
The last point I make is simply that in 193 and 194, we're turning to questions of policy, if you like. His Honour said, in some ways it's more likely that self-incrimination would be an obstacle to getting to the truth than would penalty privilege. And he rejected the coroner's submission, pardon me, not submission, but proposition at 194 that the work of the court would grind to a halt if penalty privilege were available. So we adopt that. Now, that of course was dealing with a court, a statute that specifically made the coroner's court a court of record. Your Honour knows that the 1993 Act doesn't in terms do that, but the coroner referred to a New South Wales decision of Decker, and we respectfully say that the coroner was right to draw upon that case where the New South Wales court held that even though the legislation that was being considered in that case wasn't even explicit about the existence of a court, nevertheless, having regard to matters of history, it should be concluded that the court was a court of record. The decision of Decker itself refers to a number of cases. I'm not going to take Your Honour to them, but can I mention the names of the cases and invite Your Honour to have regard to them because we have included them in our list of authorities. The first case is Attorney General and Mirror newspapers, which is number 17 on our list. The proposition we take from that is that the Supreme Court said coroners are involved in the administration of justice, and as a result, superior courts can visit contempt upon people who bring the work of a coroner into disrepute. The second case is the case of Mirror against Waller, which is number 32 on our list, in which it was held that although, of course, coroners' courts are not bound by the rules of evidence, they are still exercising judicial power. The third case is to a similar effect, Musumeci and Attorney General, number 33 on our list, in which it was held that the coroner exercises judicial power, and reference was made to what Justice Toohey said in the case of Annetts and McCann, where His Honour said that coroners' courts were courts of record. And finally, although not referred to in Decker, we invite Your Honour's attention to a very old South Australian case of Comyn, C-O-M-Y-N, against Wiltshire, which is number 24 on our list, in which Justice Stowe, S-T-O-W, dealt with the contention that the 1850 Act didn't mention a court, and His Honour said, well, a court could be sitting under a gum tree. The coroner's office is an ancient jurisdiction, and that the powers included powers to commit for contempt. Now, we say section 6.2, by preserving those common law powers and jurisdiction, picks up the capacity to deal with contempt. And for that reason, the approach taken in the Victorian Supreme Court in the case of Harmsworth, which is on the list of authorities of the family interveners, is distinguishable because in that context, the Victorian Act had a provision almost to the opposite of effect of section 6.2, saying...
So what case do you say is distinguishable?
Harmsworth and the State Coroner, 1989, VR 989, where there was a section 4 that in effect did away with the common law elements of the coroner's office as a part and parcel of creating a purely statutory scheme. Finally, can I mention a decision in which Your Honour participated, S. Kidman and Co. against Lowndes, 2016, NTCA 5, in which, in a joint judgment, Your Honour and the Chief Justice and Justice Hiley said at para 38 that a coroner may be is acting judicially and may be exercising judicial power. We say that's consistent with the New South Wales cases. And at 39, dealt with the concept of a proceeding, noting that it could have a range of meanings, but middle course, which was adopted in the context of that case, was to refer to a method permitted by law in which a judicial officer undertakes an authorised act. We would say that aptly describes the nature of the coroner's jurisdiction under the present Act. We've set out a number of sections in our written submissions that we say emphasise the curial
Yes, I've read those.
nature. I think there's only one or two I want to supplement. I don't think I had mentioned section 6.2, although Mr. Boyle's submissions picked that up. There are also provisions which invoke a test of the purposes of justice or the interests of justice, and according to the New South Wales decisions that I have mentioned a moment ago, and in particular the case of Attorney General against Mirror newspapers, it was thought to be indicative of a curial process that the body is tasked with ascertaining the interests of justice, the logic obviously being that that's only for courts to be concerned with. So we rely on the combined effect of those provisions and the sort of judicial immunity type provisions, the protection from a coroner being called as a witness and so forth, to emphasise that although, of course, we're not suggesting it's an exclusively judicial function, and it's not a typical judicial function, it is nevertheless curial, we would respectfully submit. And I turn then after that very long run-up, if the premise is then made out and we're dealing with a question of abrogation, can I just make some brief submissions at two levels about abrogation? First, addressing the position as at 1993. In our respectful submission, the Act as introduced is in much the same form as the current Act, with one or two exceptions, but relevantly Section 38 used to provide for the preservation of a privilege against questions that would tend to incriminate the person. And we would submit that for essentially the reasons Justice Blue gave in Bell, that preservation shouldn't be taken to be a covering of the field, nor should it be taken to be an implied abrogation of other privileges. For example, the 1993 Act didn't say anything about legal professional privilege and still doesn't, but no one would doubt that legal professional privilege subsists within the context of the Coroner's Act. Can I mention that Section 41, in its original form, was expressed in an unqualified manner. Section 41 is the provision that effectively obliges, or gives the coroner compulsive powers. And although you had Section 38 preserving the self-incrimination privilege, Section 41 didn't say subject to Section 38. What we draw from that, respectfully, is that Section 41 wasn't purporting to be an unconditional obligation, because it must necessarily have been subject to, for example, Section 38, and also, we would say, legal professional privilege. And we say once that is recognised, then it, consistent with the principle of legality, one can't hold that Section 41 is a source of an implication that penalty privilege was done away with. In relation to the extrinsic materials, various of the interveners have emphasised the background to the 1993 Act, and it's true that the relevant parliamentary debates, which appear in the Attorney-General's list of authorities at Item 10, reference recommendations from the Royal Commission into Aboriginal deaths in custody. In our respectful submission, however, the submissions that are made really elevate the status of that background beyond a legitimate status from the standpoint of statutory interpretation. It's clear from the second reading speech that the Royal Commission had made recommendations which were adopted, and it's clear that they included, for example, making an inquest compulsory in the case of a death in custody. And it's also true that, no doubt, a view that inquests hitherto had been inadequate led to a statutory formula that extends to the circumstances of death and not just the essential details or basic details of the death. But both of those were also features of the South Australian regime that Justice Blue considered. And essentially for the reasons Justice Blue gives, we would respectfully submit that the mere fact that the scope of the inquest is broader circumstances, and that in certain cases an inquest is compulsory, can't dictate that in all cases, including where the death is not in custody, penalty privilege is abrogated. And to the extent that the intervener's submissions focus on that context of deaths in custody, carrying with them, as they do, the greater likelihood that police would be involved or would have relevant evidence to give. That is a point to be made, I accept, but we're dealing here with the construction of the Act as a whole, and it's not, as I apprehend it, being suggested that there's a partial abrogation of penalty privilege for police, for example, or that there's a partial abrogation but only where it's an inquest arising from a death in custody.
There are no submissions to that, of that.
So we say, in effect, you can't treat an aspect of the legislation as, or more than that, a policy consideration leading to an aspect of the legislation as driving the meaning of all of the legislation.
I didn't understand the Attorney General's or the other interveners' submissions to go that far at all. They were just pointing to that historical context as one of the, I guess, mischiefs that to be addressed by the amendments to the legislation, and that pointed towards, it was one aspect that supported the, that's all they were saying, as far as I understood it.
Yes, and I accept that, Your Honour, and I'm really just making the point that one, we would submit ought not, even as a factor, allow an aspect of the coronial scheme to drive a question of construction that necessarily would govern all inquests, would govern the exposure of doctors, correctional services officers.
Well, doctors were another one mentioned in the second reading speech.
In the 2002.
To the amendments, yes.
Which I'm coming to in a moment. But ultimately, of course, it's relevant to remember that in the 1993 Act, whatever might be said about these background policy matters that led to reform, of course, Section 38 expressly preserved self-incrimination privilege. So that immediately gainsays the notion that the whole Act is to be read through the lens of getting to the truth, because one very substantial obstacle to getting to the truth is the self-incrimination privilege, at least potentially.
I know, but the argument that's put is that in the 2002, this is as I understand it, the 2002 amendments, including the amendment to Section 38, were driven with that object in mind of getting to the truth, because in the second reading speech they said things or words to the effect of that's being hampered by too many people refusing to answer questions. And they specifically pointed, or the speech specifically pointed to not criminal liability, but doctors and the like being more concerned about their civil liability.
Yes, quite so, Your Honour. I don't mean to...
And that was the mischief at which the amendments to Section 38 were aimed. In other words, squarely at, including abrogation, if you look at it that way, or partial inclusion, if you look at it that way, of penalty privilege in Section 38.
I certainly understand that to be the argument concerning 2002.
Yes.
I was addressing my learned friend who appears for Naja. I think I've only had a chance to quickly read the submissions, but I think invites Your Honour to wind back the clock to 1993 and say that even at that stage you could find abrogation, and if you start from that premise, then you wouldn't read 38.
And you say, really, on the reasoning in Bell, that it's not the case.
That's precisely so, Your Honour. Well, I'll come directly now to 2002 and just answer the proposition that Your Honour just put to me. The starting point again is text, context, purpose. Dealing with the text first, we have the question of what the word criminate means in Section 38(1)(a). It's silent as to the object of the crimination. We have set out in our written submissions, and I don't intend to repeat various illustrations of it being used in the narrower sense. We don't suggest it's been uniformly used in the narrower sense. There are, it is true, some historical examples where, whether loosely or designedly,
it's been used in many different contexts and both ways.
Can I just say in response to the family's submissions on this topic, there's a reference in those submissions to a decision which is said to be a recent authority for the proposition that criminate connotes penalty privilege. The case that's cited for that proposition is a very recent decision of the full federal court, Heron against Harper Collins, Square 2022, FCA FC 68, which concerns Section 17 of the Royal Commission Act. In our respectful submission, It is not authority for that proposition. Section 17 of the Royal Commission Act referred to crimination and then said or privilege or on any other ground. And in the paragraph that the family's submissions cite, paragraph 135, where the court said that the point of the provision was to ensure that that it covered all types of privilege, including privilege against self-incrimination, we say that can't be pinned back on the word criminate because the section referred to other privileges or any other basis whatsoever. The next aspect of the text that I'd respectfully emphasise is this question of what to make of section 38.3 and the fact that when a certificate is granted, the immunity, if I can give it that label, against the evidence being admitted is not limited to criminal proceedings.
Right.
As to that, we respectfully submit that there's a danger in working back from the forum in which the immunity operates to treat that as defining the immunity concerned or the privilege concerned. And that can be illustrated by the fact that section 38.3, if one did adopt that interpretive technique, it would prove too much because section 38.3 provides that the evidence can't be used against the person in criminal or civil proceedings or proceedings before a tribunal acting judicially. Civil proceedings is obviously much broader than proceedings for the imposition of a penalty.
Yes.
And so the scope of 38.3 is broader than the occasion for penalty privilege. Now, all of these are only considerations, but we draw attention to that proposition. Next, in section 38.2, we say it's important to note that section 38.2 could have adopted the structure of saying where a privilege is claimed and the judge and coroner decides it's in the interests of justice that the answer be given, the person must answer the question. But it adopts a subtly different form. Instead, it says where the privilege is claimed and the decision is made to give a certificate. What that means is that you can't refuse to answer the question on the basis of that privilege. And it's silent, we would say, as to any other basis to refuse to answer the question. Again, not a decisive textual consideration, but consistent with crimination, meaning just the self-incrimination privilege, at least consistent with our thesis. Finally, on the text, we acknowledge that section 41 was amended at the same time as section 38 was, and so section 41 does now say in subsection 1C, subject to section 38, the coroner may order a witness to give evidence on oath. But we say that need not be read as meaning that section 38 is the only circumstance in which you could ever be relieved from answering a question on oath. For example, privilege, legal professional privilege must still be available. But secondly, we would submit that a ready explanation for that amendment is that section 41 makes clear that under section 38, the coroner need not give a certificate, and if they do not, then that in and of itself will be a circumstance where a witness need not give evidence on oath. And so we would say it's really there to confirm or explain the operation of section 38 rather than produce a covering of the field consequence. In relation to the extrinsic material, Your Honour will have seen, I think, annexed to the affidavit of Jared Donald Clow on behalf of the Territory Attorney General, the Northern Territory Law Reform Committee report. Can I just take Your Honour very briefly to that for really one purpose. Does you want to have that affidavit? That might be the easiest way to find.
But I do here electronically, I think.
I think I can give you a hard copy if that would help.
All right, but because this seems to have done something to itself. Affidavit of Clow. Oh, I've got it. Thank you very much.
Oh, did you want to have that?
Yes, apparently I do.
So JDC 8.
8. We have printed copies of some, but not all affidavits, because some of them were 3,000 pages long.
Yes. Now, Your Honour, in written submissions, we've made the point that this report obviously was titled self-incrimination and never mentions the penalty privilege at all. But the point that I wanted to emphasise orally is that in the 2 appendices to the report, reference was made to various other provisions around Australia, both dealing with coroners' courts and otherwise on the question of privilege. And the point that we would make is that these tables contain examples of 2 types of abrogation clause, which we would say are significant to the constructional question. The first type of clause which we say is consistent is that there were examples of provisions that referred only to questions that would incriminate, and we would say that is connoting the self-incrimination privilege, and there's no question of criminate connoting a broader, so incriminate, but where the scope of the protection once given extended beyond criminal proceedings. And 2 examples of that are the provision of the Sex Discrimination Act 1984, which is in Appendix A, the 3rd item, and another example is the Independent Commissioner Against Corruption Act New South Wales, which is also in that table. It's the last entry in it. So there are other precedents of provisions that appear on their face to be squarely directed at incrimination rather than crimination or arguably penalty. But
I understand the point.
The second category is there were provisions where penalty privilege was expressly abrogated. Most relevantly, Section 33AA of the New South Wales Coroners Act, which is in Appendix B, on the 2nd page of Appendix B. Now, there was a precedent for how you expressly deal with civil penalty in the very report that the legislature had before it, but it didn't adopt that style of provision. There are numerous other examples of both categories of cases which we've referred to in our written submissions, but the point is that this very report was obviously cognizant of the different drafting techniques, and we say that has some significance. We say that what would seem to be likely is that the model for the Northern Territory provision was in fact Section 47 of the Western Australian Coroners Act, which appears in Appendix B on the first page. The language is very, very similar to the Northern Territory provision. You want to see that?
Yes.
Including criminate and expedient for the ends of justice. I think the Northern Territory Act might say expedient for the purposes of justice, but very similar model, but where when granted the protection under the Western Australian Act was only in relation to criminal proceedings. So it would seem likely in our submission that Section 47 of the WA Act was only concerned with self-incrimination, but the draftsman, or withdraw that, the drafting technique adopted in 2002 seems to have been to pick up that model but give a broader scope of immunity. Now that's where this concept of doctors and so forth comes in. And Your Honour would see that back on page 9 of the report, where the authors of the report said, under the heading, the proposed NT amendment, the contents of the draft bill follow the WA Coroners Act. But then 2 paragraphs below, 2 particular aspects of the bill may warrant further consideration. First, the policy behind the amendment is to get to the truth. As many witnesses at inquests are more concerned about civil liability than criminal charges, the policy may be more likely fulfilled if the certificate were extended to include. Now, the point I would make about that, respectfully, is what's being contemplated is extending the effect of the certificate, but not expressly contemplating broadening the relevant privilege that is being dealt with. Now, the proposition that many witnesses at inquests are more concerned about civil liability, again, Your Honour, that's broader than civil penalty.
Yes.
It might be dealing, and I would respectfully suggest it is dealing with this. A medical practitioner, a medical practitioner might have a legitimate fear that evidence might incriminate them, for example, some form of manslaughter, but they're not so worried about being prosecuted, albeit that they have a basis to claim the privilege. They're worried that they'll be sued by the family or dependents. And so the scope of the protection travels beyond criminal, but it doesn't necessarily connote that the privilege in issue travels beyond the criminal.
Yes.
We say the second reading speech in Parliament is to the same effect. And so there are arguments about whether Section 38 engages with penalty privilege. We say it's not engaging with penalty privilege, it's engaging with self-incrimination privilege. If that proposition is right, we say it's a large step to say, oh, well, maybe Section 38 was only directed at self-incrimination privilege, but by implication, you've got a complete abrogation of penalty privilege. I've rehearsed that argument before lunch, and I think Your Honour understands the point. Having said all of that, in the great traditions of having a bob each way, if Your Honour wasn't satisfied that penalty privilege is preserved holus bolus, which is our contention, we would adopt as a fallback proposition what the Attorney-General says about taking a beneficial construction, because wherever privileges are concerned, one should strain in favour of the preservation of those sorts of principles. Finally, if I may, and I think I've been a bit quicker than I thought I would be, it is tempting to ask questions such as what rational policy objective could there be for directing a provision at self-incrimination privilege and leaving alone penalty privilege. But we would respectfully submit that, first of all, the principle of legality doesn't turn on such kind of suppositions. It requires it to emerge with the requisite clarity that it was intended to be dealt with, even though not stated. But even ordinary principles of statutory construction, and I think Mr Boyle might be proposing to address Your Honour briefly on this topic, urge against turning what would be a desirable policy, or perhaps an assumption as to what would have been a better way of dealing with something, into the interpretation. Of course, purpose follows from text.
In your written submissions.
I did, and we just make the final point that, or 2 final points, if I may. First, that one possible rhetorical answer to the rhetorical question is that penalty privilege just hadn't been a problem for the coroner's jurisdiction. It was self-incrimination privilege that had been claimed, and it is my respectful submission, not without significance, that the law reports aren't littered with arguments about this. Now, Your Honour might say, well, perhaps no one's had the temerity to argue it, but perhaps it just hasn't proved to be a great difficulty. Not the sort of difficulty that would mean you must
We're
read in and-
speculating here, aren't we?
We are. But my point is a negative one, that one can't speculate that because, for example, it would impede a full investigation into deaths in custody, penalty privilege can't possibly apply, because that really does assert...
That's not the argument that's put against you. The argument is a much more nuanced one, and that is that if you are adopting a purposive approach to construction of this section, then those are relevant matters to take into account.
Very well. And the final point is, if one was to look for a rationale that would distinguish between the two privileges and their treatment, I would come back to the point I made earlier about section 35(3). It is at least perhaps one incidental aspect of the coroner's function that there may be references to police for prosecutions or to the DPP. And it could be supposed or argued that as an adjunct to that, there's a qualified right to overcome self-incrimination in the right case. But because there is no role of referring disciplinary matters, there's no need to confer a right to abrogate the penalty privilege. Now, you'll find no evidence of that in the extrinsic materials, but it just goes to show that if one wants to start guessing at rationales, there are lots of conjectural things that can be said. We say the result here is not irrational, bizarre, in the way that it was in Pine Board. Anything else, Lou? And if the court pleases, those are our submissions.
Yes, thank you very much, Mr. Doyle. Now, I take it that Mr. Boyle will now...
Yes, Your Honour. And I'll be...
Can I just raise one matter, Your Honour? It's Mr. Game for the attorney.
Yes.
There's a proposed second declaration sought, which is described as 2B. It's not really an amendment. New declaration. We oppose that amendment, and we oppose the putting of that. And it's a matter for Your Honour how Your Honour wants to deal with it, but I can explain the basis of our objection now. Or
well, could we ask Mr. Boyle if he is content with the amendment proposed by counsel for Mr. Rolfe, Constable Rolfe?
Yes, well, that's what I was going to say, Your Honour. I might short-circuit that and say that having had the benefit of both the attorney's submissions and further time to reflect on it, we no longer press what they describe as, I think in paragraph 8 of the Attorney General's submissions, as the declaration 2B, and instead effectively slipstream onto what Constable Rolfe's team have put forward as 2A.
Yes.
Rather, yeah, 2A effectively.
Thank you very much for that. Well, and Mr. Boyle, can I just ask you, because we have very limited time, if you could restrict your submissions to anything that you need to say in addition to what's already been very amply covered by Mr. Boyle?
I really only have 2 points to make very briefly, Your Honour, and I think I can make them in about 5 to 10 minutes.
Thank you.
So the first point, and this goes back to something that Mr. Doyle was just exchanged in a debate with Your Honour about, in relation to the question of guessing, in effect, at the purposes to be achieved by the amendment and the relevance of this concept of getting to the truth, and the idea that somehow that purpose might itself be thwarted if it were the case that penalty privilege effectively remained untouched and unabrogated by the section. Now, we've addressed this in paragraph 13 of the written submissions, and I don't propose to really return to anything that's already said there, but I've given Your Honour the reference to what was said by their Honours Justices Gagler and Keane in Taylor and Owner's Strata Plan, which is a 2014 volume 253 of the Commonwealth Law Reports, beginning at page 531, and the relevant paragraph is at paragraph 65. In that regard, I wanted to just draw to attention what's stated in section 62 capital A of the Interpretation Act 1978. And what that section provides is for a construction to be adopted which would effectively advance the purpose is to be preferred to one which would not. But in the present case, effectively, both constructions propounded on either side, one by the interveners and one by Mr. Doyle and myself, both would advance the purpose, in my submission,
Both would what? Advance the
both
purpose.
would advance the purpose of getting to the truth, because what has effectively been provided, as Mr. Doyle's already taken Your Honour through, is, and it's also done quite thoroughly in the submissions of NARJA, to demonstrate that prior to the 2002 amendment, there was a blanket privilege operating that meant that one could refuse to answer a question on the basis of self-incrimination privilege, and in our submission other privileges. And then 38.3 was amended to effectively provide a road through that in limited circumstances. And so
you say that amendment is limiting. It doesn't matter whether you say whether it's applied only to self-incrimination privilege or to that plus the penalty privilege. It has had the effect of making it easier to get to the truth. So both would advance. Is that what you're saying?
Yes, both would advance the purpose, and in those circumstances, Section 62A doesn't permit the court to do anything further in terms of discerning a best purpose. The provision can be contrasted with that which was considered by the High Court in the decision of, let's find the reference, Your Honour. It's Lacey and the Attorney General of Queensland. It's in volume 242 of the Commonwealth Law Reports at page 573. And in that case, the Queensland equivalent of, in effect, section 62 capital A was one which required the promotion of the best achievement of the purpose. And so my submission is that a provision like that can be contrasted with 62A, where effectively once you have competing constructions which both promote the purpose, then there's no longer any difficulty. Your Honour is still effectively confronted with having to try to reconcile what the appropriate construction is, and in my submission that falls back into the text.
Yes.
And in that regard, the only other thing which I wanted to draw Your Honour's attention to was the decision of Carr and Western Australia, which is in volume 232 of the Commonwealth Law Reports, beginning at page 138. And in paragraphs 5 to 6 of that decision, in the judgment of His Honour Chief Justice Gleeson, he notes that effectively a purposive construction can be of little assistance where there's a competing balance being struck, and you've got uncertainty as to how far the provision goes in order to achieve the purpose. And he talks there in the Chief Justice's judgment about the problem of effectively not all, the pursuit of a purpose by legislation is not one that is taken at all costs. And so the submission that we make here, consistently with what Mr. Doyle has already said, is that the amendment in 38 only goes so far, and it's not appropriate, we say, or correct to go so far as others have said. And those were the only matters that I wanted to address Your Honour on.
Well, thank you very much for that, Mr. Boyle. Right. I'm just making a note of that final point.
No, we can't. We've lost. What do I have to say?
And I otherwise adopt all the submissions made in writing by both Constable Rolfe and Sergeant Bowens, and also adopt the submissions that were made by Mr. Doyle.
Yes, thank you very much. Thank you. Now, Mr. Game,
So
you're up next.
can you want to hear me?
I can hear you, I can barely see you, but I suppose that's not going to be altered much.
So something has happened at this end, which is we can't see anybody now. We can only hear you. And I'm not entirely sure that I can fix that. And our monitor person is not here with us, and we'll have to get him back. But I can make a start, although I won't be able to see. Probably won't be able to see anyway.
Well,
Your
really,
Honour.
it's most important that we can hear you, isn't it?
Happy to press on, even though I can't see you. So I'm sorry, but I'll press on.
Yes, thank you.
About how we're going to proceed. It's maybe some senior counsel giving the hard work to the junior counsel, but I'm going to address first on the statute and what we see as a relatively short way home to this case. And then Ms Edwards is going to address, hopefully, pointedly and relatively briefly, to the aspects of the authorities that you were taken through with Mr Doyle, but to the end of saying one simply cannot ignore Daniels, and this court is obliged to follow Daniels and Rich. And that's pretty much the end of it in terms of this question about still trying to apply Pine Board. Now, I'm going to leave that to her. Now, so first, in respect of this question about whether or not these are curial proceedings, relevantly speaking, we say that they're not in the relevant sense of curial proceedings that may expose to penalty, even curial proceedings may, as it were, set up an exposure to penalty in some other proceedings of the kind to which Mr Doyle referred. These are not those kind of proceedings at all. And we set out our submissions on this paragraph 59 and 60, or actually through to 62, and I won't repeat that. We do say that
Sorry, 59 and 60 through to 62.
Of our submissions, Your Honour. I won't repeat that, but that is the position that we put, that quite clearly these are not relevantly curial proceedings in the context of having parties, pleadings, discovery. Of course, a coroner is supposed to must act judicially, but these are proceedings of an executive kind. And, Your Honour, and that is pretty much what the Coroner found in paragraph 30, and we support that finding. We also observed that in Bell, it appears to have been assumed at that point in the judgment that the proceedings were not curial for the purposes of His Honour resolving that question. So,
What paragraph in Bell were you referring me to?
So where I'm referring you to in Bell is this, Your Honour. If you go to Bell, you'll see paragraph 49. It is common ground that penalty privilege can be claimed in curial proceedings, notwithstanding that a penalty could not be imposed.
Sorry, which paragraph in Bell? I'm sorry, I missed that.
49.
Sorry?
49.
49.
140.
Oh, yes, okay, 149.
And then you see the whole case following on from...
So this is becoming unsatisfactory. I can't hear you, Mr. Glass. There's too much interference. There's just... you're cutting in and out.
Yeah, we might. Can we reestablish the link?
Sorry, Your Honour.
Would you like... could I just stand down for a couple of minutes and see if we can do better with the sound and even get your picture back?
I've got your picture back now, but we will see if we can do better. Is that better with the sound already?
Yes, it is.
But something happened.
Council here are nodding so that everybody thinks so. We'll
then
proceed.
So what I was going to say is the discussion proceeds in 151 and following. that the focus is about penalty privilege outside curial proceedings. And that is what the context of the discussion thereafter. So there really isn't support anywhere for the idea that in the relevant sense with which we are talking about, that coronial proceedings are curial in nature for the relevant purpose of determining the question about abrogation of various privileges. They do not have those characteristics. Now, I'm not going to take Your Honour through all of the relevant provisions of the legislation, but you'll see one particular provision. Now, first of all, we see reportable deaths extended in the definition to section 12.8 to where death was caused or contributed by injury while held in custody. Section 26 is a provision that marks out this act of others. It goes further.
I'm sorry, Mr. Glass, for losing you again. I think when you put your head down.
Oh, okay. Sometimes you call me Mr. Glass, but actually my name is Mr. Game.
I'm sorry, Mr. Game. I've said that at least 3 times and I apologise.
All right. It's fine. Anyway, so the point about section 26 is that, and this really responds to something that Mr. Doyle said a little while ago, that all of these pieces of legislation recognised the need for proper investigations following the Aboriginal Deaths in Custody Commission's final report.
Yes.
But section 26 goes further, and it actually places obligations of a specific kind on a coroner in respect of deaths in custody, and we see must investigate and report on care, supervision and treatment, and may investigate on a matter connected with public health or safety or the administration of justice that is relevant to the death. And then section 34, if we just note, section 34, subsection 1A also has its breadth because it has little 5 that includes any relevant circumstances concerning the death and it goes on. And then little 2, a coroner may comment on a matter. So they are both obligations and powers. So, Your Honour, this brings one then to section 38. And there is a clear legislative context to this, and I want to briefly take you to the second reading speech, which is JD 7 behind the affidavit of Mr. Clow.
Can I just make sure we've got that? Do we have that one printed out? Mr. Clark? Thank you. Brilliant. Clow, sorry. JDC 7, yes?
Now, so this is in context where section 38 said that a person shall not be compelled to answer a question that may tend to incriminate the person.
Yes.
So now, so it's in this context, and then on page 454 of the debates, there's a paragraph in the right-hand column that begins making sensible recommendations. There's the objective, yes, and then the next paragraph, and then it says it may be that it talks about medical practitioners refusing to answer questions on the basis of self-incrimination. Then it says it may be that in these cases the concern for these witnesses may not be that she or she may be charged with a criminal offence, but that civil or disciplinary proceedings may result from the giving of evidence. Now, one committed a criminal offence, that would expose one to civil or disciplinary proceedings in itself. So it's kind of, we have the excuse if criminal offence, but we don't have the excuse if it's something less. Is kind of the idea. Then we look to the report itself. We see that the report, you see in the letter written by the President, the letter is, the report is driven to a substantial degree by concerns of the coroner. And we see at the end of the letter, if a certificate is given, the protection of the certificate should extend to civil as well as criminal proceedings.
I'm sorry, we're looking at the Law Reform Committee report at JDC 8.
Yes.
What
So
page?
Okay, so at the front of, you turn to the second, at the front of it, there's a letter, the 2nd of October 2001.
Yes.
And we see in the second page of the letter, I also had the opportunity of discussing with Mr. Kavanagh. And the very end of that letter, it refers to the suggestion that if a certificate is given, the protection of the certificate should extend to civil as well as criminal proceedings, as in the Tasmanian legislation. Then, Your Honour, if you go to the report, and I won't read this to you, but the body of the report at page 7.
Yes.
In our submission, very much support the position that the purpose of this was to ensure that accounts could be obtained where people had exposure of less than a criminal offence, but an exposure to civil penalty. And we see on page 8, again, there's a paragraph that begins, obviously powered to seek evidence, and then it goes on, in these cases it is frequently the lesser offenders or those not offending at all, but caught up in a web of circumstances, etc., who can provide evidence vital to the investigation. It is for the coroner to determine whether the price. And so then Mr. Kavanagh expresses his concern in that following paragraph. So, and we see again, on page 9, under the proposed amendment, we see in a paragraph that begins 2 particular aspects. And it says, in a third sentence, as many witnesses at inquest are more concerned about civil liability than criminal charges and guilt, the policy may be more likely fulfilled if the certificate were extended to include any criminal, civil or other proceedings. So we say that the context is plain enough. Now, the question in our submission, if we turn to section 38, is whether or not either the position put by Naja that the penalty is not a substantive right, it's at most a rule of evidence. We say that that the short answer, we prefer put this in a different. We see that is an argument that's well and truly available on the authorities, and it's not relevant that this case came after Pine Board. This amendment came after Pine Board, but shortly before Daniels. So it may have been based on a misunderstanding about what the law was. But we say, and this is Mr. Doyle's fallback position, that Mr. Doyle's fallback position is our front and centre position, which is what is happening here, is that it is this legislation is aimed to be able to get at the truth, but it's also a protective provision. So if you want to protect testimony that exposes people potentially, let's say, to criminal liability or to civil penalty, you're not going to want to be going into an inquiry as to whether it's on the fine point of one or the other, because, for example, a criminal offence is obviously going to expose you to a civil penalty of some kind or penalty of some kind if you are in a position of employment with the state, for example, as a police officer or a prison officer. So it's not really feasible to be sitting around saying, well, this one's a crime, that one's a civil penalty, when you've got a protective provision of this kind. And so this legislation is intended to jump over that. It's protective. And that's the kind of driving idea of this, which really means Mr. Durrell's argument just doesn't work, because none of the cases he's taken to actually deal with this kind of situation. Now, he also relied on the idea that there's a discretion whether or not to give a certificate. But this is quite important, Your Honour, because it works in a, funnily enough, it works in a counterintuitive sort of a way. So sometimes if a person is exposed for a terribly serious offence and there's a case coming up or potentially coming up, much more likely to not give them the certificate, but not require them to give the evidence. And that's what happens in those 128 cases all the time. I say all the time, often enough in criminal trial. In your court, and presumably I don't practice in your court a lot, but in trial courts where 128 of the Evidence Act comes up, that's what happens. But in a situation like this, when the less, let's say it's the exposure to civil penalty but not to criminal charges, it's likely to be the situation that you would decline to give somebody a certificate because they've committed some breach of discipline, for example, for which they may come before either the commissioner or before the tribunal. So that's how. So this provision is intended in our submission to pick up whatever that exposure might be of an adverse kind to both crime and to penalty. And as I say, were it otherwise, the whole thing would collapse to the ground because in respect of police officers and prison officers, because things that would incriminate them would certainly expose them to civil penalty. So there would be a loophole that would bring the provision to the ground. But as I say, why we prefer the submission that, so what we say is happening here is penalty privilege is not sitting here waiting to be abrogated. Penalty privilege is on the sidelines and it's being picked up and both identified and then accepted as a basis for claiming privilege. So that it's actually given by Section 38 and then it's qualified. And that's how it works in our submission. And that's a purposive, protective operation of the provision. It facilitates the obtaining of testimony and it makes sense. So when one goes through.
Could I just ask you, Mr. Gain? I'm sorry. Could I just ask you this? That purposive and protective interpretation of Section 38 works whether the section both gives and qualifies the privilege, or whether it both abrogates, or whether it simply qualifies a pre-existing privilege, doesn't it? Isn't the coroner right in saying that?
That's right. Yeah, so what I'm saying, that's why there's a short way home in our respectful submission, is that whether it brings it up, recognises it, or whether it identifies something that exists and has to be addressed, either way, the outcome in our respectful submission is identical.
Yes.
And so it's as if the legislature says, this is a problem that has to be dealt with, and this is how we're going to deal with it. So that in every case, in a way, it doesn't matter, because in every case you can bring forwards the thing that you're concerned about. And if the thing is entirely trivial, then you're unlikely to get a certificate. But if the thing is terribly serious and you're likely to go to trial, you might not get the certificate, because the certificate ain't going to protect you for X7 kind of reasons. That's to say, it might commit you to an account in a non-curial context where you're not obliged to give your account until you stand trial before a jury and so forth. The kind of X7 and Lee type of considerations that would apply in that situation. So as I say, then if you look at the words, there's no magic in criminate, and we've given, and that comes from the Western Australian provision. Tend to criminate, of course, those words come up in many of the provisions, but tend to, that's the idea, may lead to, or may assist in establishing. So that, again, you already have a kind of an idea of qualification. Now, how would you work that out? If the second there was an exposure to a civil penalty, to an exposure to, for example, disciplinary proceedings, how would you kind of stop then and say, oh, well, it tends to criminate you, but that's not going to help you because you're also exposed to a civil penalty, you're also exposed to disciplinary proceedings, so I can't give you the certificate. So that's the kind of, and there is an aspect to the fact that Mr. Rolfe is playing dice. He's playing dice because if Nadja's submission is correct, he ends up having to give the account with no protection at all. And we recognise that construction is open, but we say that our construction is preferable and should be adopted. And then if we proceed through, it's 38. He may not be pursuing it, but Mr. Bones's counsel said that Section 38 is a power to order a witness to give evidence. It's not. It's just about the giving of the certificate. It's just about the powers in 41. But then we see
41.
It's in 41, yes, and the words subject to Section 38 are the additional relevant words that were brought in by the amendment. So, but then we see subsection 2 is the machinery of it, no longer entitled to refuse to answer. So you've got the certificate, now you're going to give the evidence, i.e. it's going to assist, as it was at the time, Mr. Kavanagh or any coroner. Has to be the coroner, it can't be a deputy coroner with deaths in custody, but says that's the machinery of it. Then subsection 3, now subsection 3 is picking up the idea in the second reading speech and the report, but the idea that it would just be criminal offences not admissible in criminal or civil proceedings or in proceedings before a tribunal. So there is a tribunal under the Police Administration Act, and there is also a person, potentially in the shape of the Commissioner, who can exercise powers in respect of less serious matters that don't go before the tribunal, where things like cautions can be imposed. So the argument that was put to you by Mr. Doyle on something along these lines, well, don't just But don't read subsection 1 down by reference to subsection 3. That's consequential. But the thing is that Project Blue Sky and every case that we read tells us to read everything, and you have to kind of understand them together. So why would you just do it in respect of criminal offences, but not things that expose you to a civil penalty? Now then he says, oh, well, maybe their concern is in relation to civil proceeding, not penalty privilege, not civil penalty, but civil proceedings. So you have protection in relation to exposure in crime and to findings, perhaps in civil proceedings, but not to penalty privilege. And it just doesn't make sense. And the whole point of this is to feed this as the context of subsection 1 to catch those things that expose people to some form of adverse finding, whether it be as a crime or a civil penalty or a punishment or a disciplinary proceeding. It's intended to catch them. And that's how it works. And it actually works quite well, because you're seized of the discretionary issue that I explained to you before about balancing up whether to grant it, but you're not engaged in filleting one way or another, whether something exposes you to a crime per se or to something less, or that something that exposes you to a penalty but doesn't expose you to a crime, and therefore you don't get the certificate. This jumps off.
So, Mr. Game, can I just ask you this? Did you perhaps phrase it a little too widely in saying that the whole point is to catch things that expose people to any adverse consequence? Because although it says that you can't, because it's so, like civil liability, for example, it is not caught by the wording of 38.1, even though civil proceedings are mentioned in 38.3. Would that be right?
I accept that, yes. I'm sorry, I got carried away with myself, Your Honour. Not the first time. Anyway, yes, that's absolutely correct. You have to read them together, just in the way that I said.
Yes.
But now, so the anyway, that's section 38, and that's how it works, we say. And it's not a clumsy or difficult or unworkable provision. It actually can be made to work quite coherently with what coroners, I beg your pardon, are required to do in coronial hearings. Now, there are some further sections I just need to refer to, and then I'm going to hand over the hard work to Ms. Edwards. But section 39 is obviously important, because if one lands on the point that these are not rules of these are not substantial rights, but at the most rules of evidence, we see in section 39 that a coroner can inform him or herself not bound by the rules of evidence. So again, it's a provision that frees up a coroner to seek the truth without being caught, for example, by the hearsay rule, where some very important evidence might come. So again, something that facilitates the obtaining of the truth. And then section 41 is the power. So that is how, and we see, as I said before, subsection 41(1)(c) had brought in the word subject to section 38, and so that basically is how we say this works. Now, and that's all I want to say about it, but I do want to take Your Honour briefly to some provisions of the Police Administration Act, and just to show Your Honour something that's of some relevance to our submission, but I think of more considerable relevance to the argument that Naja wishes to put. But I just wanted to direct Your Honour to these provisions. Section 76, 76(1)(d), and that's how this looked in 2001, and that's very similar to the kind of provision considered in Morris in the High Court, where the privilege was found to be abrogated. And then we see section 77, effective criminal proceedings. For the avoidance of doubt, anything may be done or continued under this part, notwithstanding that criminal proceedings in respect of the matter to which it relates have been commenced or are contemplated, and that gets over what I would describe as McMahon and Gould type of considerations. That's to say priority of proceedings. And then we come to section 79A. Now, in one way, section 79A might be regarded as being unnecessary, but in New South Wales in 2013, a decision was handed down in a case called BAF. And that is the source of the problem that required the legislature to revisit section 79A and to make it explicit so that it says this section, and we've provided Your Honour with with the second reading material in relation to that, and that's, I won't take you through it, but that's JDC 11, and the history of that case called BAF is explained as being the trigger of this. Now, the point about it is...
I just like to make sure that we've got, keeping track of what's in evidence. You're tendering, I take it. I mean, I know normally the affidavits are read, but it's easier to keep track of them if, if they're tendered as Mr. Doyle did. So can I mark the affidavit of Jared Donald Clow, Exhibit P2, along with Exhibits JDC 6,
yes,
JDC 7, and now you say JDC 11. Is that right?
That's correct, Your Honour. Yes.
All right, thank you. So someone can keep track of that. All right, thank you.
If you just look at JDC 11,
yes,
we see on the second page.
Second page?
Oh, actually, depends on the print. If we look at does Your Honour have page 5,117?
Yes.
So it starts at the Second Amendment, the bottom right-hand second column.
What does it do? Yes.
If you start on
yes,
the second,
I have that.
the Second Amendment. So then it talks about Morris on the next first column of 5118, and then it says that there was this decision called BAF, which said that a police officer was not obliged to be answered the questions, which may or may not be correct. And I would doubt very much, I mean no disrespect whatsoever to the learned judge, but it's doubtful that it was correct in the light of Morris, but nevertheless, brought this section to 79A to make the point plain. But so the point about section 79A is that it then says in explicit terms, this section applies to a member is required to answer questions and then not excused from answering a question that may A, incriminate the member, or B, make the member liable to a penalty. Now, the point about this is
Where do I find that? Oh, that's the actual wording of section 79A.
Yes.
Okay.
So the only, from our perspective, the relevance of this is more limited than RJ makes of it. But we do make a point about it because we say, look, the backdrop to this is that the police officer concerned does not have penalty privilege in the substantive context of police discipline.
Yes. Can I just say, though, that isn't that a matter that's more relevant to the coroner's job, assuming that your interpretation of Section 38 of the Coroner's Act is correct? Isn't that more relevant to the coroner's job in deciding whether a certificate should be issued or not?
Yes, that's exactly right, Your Honour. So we see it of some significance, but limited to that you've just raised with me. But we don't wish to add to it. But those are the statutory provisions. That's the statutory context I wanted to take you to now. As I said, I'm going to leave the hard work for Miss Edwards, who's going to address you as needed on the cases.
Yes, thank you, Mr. Game, and I apologise once again for getting your name wrong, not once, but I think 3 times.
So it's been a blight in my career, Your Honour. Judicial officers calling me all sorts of different.
Yes, Ms. Anderson.
Edwards, Your Honour.
There you go, I've done it again. I'm sorry, Ms Edwards. This is a blight on my entire character, I'm afraid.
Your Honour, I don't propose to go through the cases in detail like Mr Doyle, and if I could give you, Your Honour, an overarching view of the three propositions where I'm going, there are three. The first is that the attorney takes no issue with the correctness of the decision in Justice Dean in Refrigerated Express, and I don't mind if I just refer to the cases without their citations.
Yes, they've been put on the record once, I think.
So our first proposition is that Refrigerated Express and the line of authority that flows from that up to and including the decision of Justice Edelman in QC Resources, which is referred to in the plaintiff's submission, relates to a particular issue, which is civil actions and discovery and interrogatories within those actions, and can be availed by defendants in civil actions in certain circumstances. And we would respectfully say that that line of authority is to some extent a red herring, because there's no quarrel that that is something that's available to defendants in civil actions. The second proposition is that it's simply not open to follow the reasoning of the plurality in Pine Board without taking account the significant qualifications to that reasoning in the decisions of Daniel and Rich, and that not only does the reasoning with respect to penalty privilege in Pine Board no longer hold good, but that effectively that decision stands with respect for very little anymore, because the decision in Daniels can be to some extent seen as a wholesale attack on most of the underlying reasoning in Pine Board, and thus any approach that uses Pine Board as a foundation is on a very flimsy foundation after those two decisions of the High Court. And the third proposition, which is connected, is that the criticism that was made of Justice Brennan's decision in Pine Board is illustrative of the attack on Pine Board more generally, but it doesn't support the plaintiff's idea, and that's the notion that the fact that Justice Brennan was criticised for failing to adopt the approach of Potter and Minahan and the principle of legality, it doesn't follow that the court there is endorsing the notion that the principle of legality applies to penalty privilege. And in fact, we would go so far as to submit that the court in Daniels has unambiguously stated that the opposite is the case. If I could start, Your Honour, just by taking Your Honour to the decision in Pine Board.
Yes, hang on. Wait a minute. Just let me find it. Yes.
If I could take Your Honour to paragraph 25, which is also in the reported version at page 335.
What? Three, 335. Yes. Sorry, yes, I have it.
Your Honour, at the last paragraph at the bottom of that page, there's a paragraph that starts, "It's well settled," and Mr Doyle took Your Honour to that this morning. That raises the issue, which was our first proposition, which is there's no controversy between the parties that a party, which would in this case mean a party to a civil action, cannot be compelled. And Your Honour will see in that very paragraph there's a reference to civil actions and a reference to discovery and interrogatories. And there's no dispute that that is the case, and nor is there any dispute that Justice Dean in Refrigerated Express drew a distinction which is still being applied in courts today, which is a distinction between a court refusing to make an order for discovery or pleadings or for interrogatories where the proceeding itself is for the imposition of a penalty, but requiring effectively parties to do it on a case-by-case basis where the exposure is in a collateral proceeding.
Yes.
But the next point that's made in Pine Board is, again, in relation to something which is no longer in dispute, which is whether or not that rule can be confined as a principle of discovery or equity, and it's determined that it's a reflection of the law of privilege.
Yes.
And that determination is made at paragraph 15, which is on page 337. And it's in the middle of the page, Your Honour. There's a paragraph that starts, accordingly, the construction of section. Again, there's no issue. There's no issue with those principles that are expounded in that paragraph, and many of the cases that are relied upon in footnote 41 are merely reflection of that paragraph. But then the next point that the court turns to when it says before turning to 155, we need to deal with one further point, is whether or not the penalty is inherently incapable of application in non-judicial proceedings.
Yes.
And the analysis that follows, and I won't take Your Honour to it, but it goes on for several pages and it looks at streams of authority pointing in either direction before it concludes at page 341, which is at paragraph 27.
Yes. That's in the middle of the page. We're not prepared to hold the privilege is inherently incapable. Yes?
Yes, yes, precisely, Your Honour. And as we'll go to later, the court said in Daniels, well, that doesn't necessarily mean the opposite follows.
No. And isn't a key part of that paragraph the issue of its availability falls to be decided by reference to the statute itself? And that's your point, isn't it?
It is certainly one of my points, Your Honour, but there's 2 points, and that's certainly one. One is that it falls to be determined by the statute, but then there's this issue of default presumptions, and when one is employing statutory construction, does one employ the default presumption of the principle of legality or the principle in Potter and Minahan that you don't take away a common law right without express words or necessary attainment, or is it a lesser principle which would give rise to a lesser default?
Yeah.
The reasoning that follows in after paragraph 27 is based on the assumption that it is a fundamental common law right, but it has been excluded, and as Your Honour observed this morning, which therefore makes this decision obiter for the perspective of the plaintiffs. But the court essentially provides 3 reasons why the privilege is excluded in Pine Board, and the court comments on all of those reasons in Daniels. The first is that the Commission would find it virtually impossible to establish the existence of contraventions, and that appears at 343 at paragraph 33.
Mm-hmm.
The second reason is essentially that they're not troubled about the fact that their approach would make the express abrogation of self-incrimination in subsection 7 to be otiose. They say that doesn't matter, it doesn't affect our analysis. And then the third reason, which is significant for present purposes, is that, and this is at the bottom of page 344 at paragraph 38, the bizarre consequences of the appellate's construction, and that is that it would set up a lopsided situation where a person could object on the basis of penalty privilege but not on the basis of self-incrimination, and they describe that as irrational. Your Honour, only that third contention survives in Daniels, but if I could just briefly mention the decision of Justice Murphy, because Justice Murphy's decision in Pine Board was endorsed by the High Court in Daniels. Justice Murphy at paragraph 5, which is at page 345.
Just let me mark this one first. Yes.
Justice Murphy is respectfully somewhat dismissive of the penalty privilege and refers to it as the origin arising from judicial hostility to common informers' suits to penalties. Says that application outside that context is difficult to justify, but it would be absurd if a witness could refuse to answer on the basis of a lesser privilege, but not on the basis of self-incrimination. And then he goes on at page 346 to emphasise the distinct features of self-incrimination, which are very different in nature and origin. And we would rely upon that and the reference to Sorby in that context, because the fact of lesser privilege is significant in the High Court reasoning which follows.
Sorry, where do I find that? Can you just, which paragraph?
The paragraph in Justice Murphy's decision.
Justice decision. Page 346?
Yes, 346, there's a heading privilege against self-incrimination. And there's some detail which follows on page 346.
Yes.
And ongoing, where His Honour makes very clear that it is a separate and distinct privilege because of its origins, its history and its implications. And again at page 347, right at the bottom of the page, he then comes back to the idea that it would be absurd.
Ah, yes, I see that.
So he's contrasting and comparing a lesser privilege and a greater privilege, and then coming back to the notion of an absurdity, a lopsided outcome that would preserve one and not the other.
Yes.
And then if I could take Your Honour now to Daniels.
Yes.
I'll go straight to paragraph 9, Your Honour, which is on page 552.
Yes.
Your Honour, that's in relation to legal professional privilege, which was the subject matter at issue in Daniels, as Mr. Doyle outlined this morning. But what we say is significant about those paragraphs is that a sharp distinction is being drawn between legal professional privilege on the one hand and penalty privilege on the other. And that starts at paragraph 10, where it's referred to as a rule of substantive law, not merely a rule of evidence, and not confined to discovery and inspection and the giving of evidence in judicial proceedings. And those contradistinctions we rely upon because we're saying that a distinction is being drawn. And then that goes on at paragraph 11, again to say that it's not merely a rule of substantive law, it is an important common law right, or more importantly, an important common law immunity. And in the context of that paragraph, that is, it's not just a common law right or even an important common law right, it has special status, which gives rise to the Potter and Minahan principle.
Yes.
And then it goes on, starting at paragraph 12, to turn to the reasoning of Pine Board. And Mr. Doyle took you to 13, which refers to the different types of privileges. And as Your Honour just noted, at paragraph 15, the court says that the finding that it's not inherently incapable doesn't mean that it is available, and they refer expressly to Justice Murphy in that paragraph. And ultimately, his approach, His Honour's approach, Justice Murphy, is going to be adopted by the court in Daniels. But there's, and I don't mean this disrespectfully, there's a comment that at paragraph 16 which might be regarded as a swipe at Justice Brennan, because it stated that
he didn't give effect to the rule in Potter and Minor.
Yes, but the underlying premise, of course, of that is that he was assuming that penalty privilege was a fundamental common law right, and the court in what follows is going to make unambiguously clear it disagrees with. And then the attack on the reasoning of Pine Board continues, but it goes at 17 to those two key bases, one that it's too hard for the Commission to prove. They refer to that at 17, and then they say the second was the irrationality, that idea that it's absurd to create a lopsided outcome. And then they refer at paragraph 18 to the notion that they weren't troubled by the express abrogation in subsection 7. They say, well, that's contrary to a principle that would give it work to do. And they develop that for some time before they return to the construction of legal professional privilege. But at paragraph 25, which is on page 557, at 25, they say the first question that arises is whether the approach in Pine Board should be followed. And the plurality continues, there are a number of difficulties with that course. And they again refer to the problem with Justice Brennan's approach, and then they also refer to the difficulties with the approach. And then they refer to a different difficulty at 26 and 27, which relates to the first bases adopted by Pine Board. And then they refer to the problem with assuming that the express abrogation in subsection 7 is otiose, and they say that's inconsistent with statutory construction. That's at 28. And at 29, the court concludes, or those three judges, those four judges conclude, the majority in Daniels conclude, given the difficulties with the approach, that approach should not be followed for the purposes of section 155. In our submission, that is effectively overruling the bulk of the reasoning in Pine Board, with one carve-out. And that is, they go on to say, that is not to say Pine Board was wrongly decided, and we respectfully agree with Mr Doyle that what the court is saying there is we're not overturning the decision in Pine Board because the outcome is one that we agree with. And they go on to say, and that is because it can be supported by the reference to the absurdity. So that's what's left standing, as it were, after that review of the decision in Pine Board. And they do go on to talk about Naismith and McGovern at 31, but as I've indicated, that's not controversial, that principle applies. But what they then say at paragraph 31 is, however, there seems little, if any, reason why that privilege should be recognised outside judicial proceedings. And so in our submission, what that is saying is that there is a box where penalty privilege applies, and we're keeping it in that box, and we see no reason to extend it beyond that point. And they finally make a reference to the fact that self-incrimination is not available to corporations, which of course was something that was assumed without being decided in Pine Board. And Mr. Game is reminding me that it says that the privilege against exposure to penalties serves a particular purpose, which is those who allege criminality or other illegal conduct should prove it. And I'll go very, very briefly to Rich, Your Honour, which is just to say that if Your Honour could go to paragraph 23, which is on page 141. It's clear that the court in Rich has wholeheartedly adopted the analysis of Daniels, and that means that it's wholeheartedly embraced the attack on Pine Board, and that is followed through from 23 at 24. It acknowledges that part of Pine Board I mentioned in 15 that's not controversial, which is that it goes beyond equity, but then says it acknowledges that the underlying purpose is to say that those who allege criminality should prove it or other illegal conduct, and then it says that is not to say that the privileges against exposure to penalties or exposure to forfeitures are substantive rules of law, like legal professional privilege having application to judicial proceedings. So, whether or not an inquest is a judicial or a curial proceeding, as a principle of statutory construction, we would say that it's clear from Daniels and Rich that there isn't a default presumption applied to penalty privilege as a fundamental rule of law that Potter and Minahan would apply. And I won't take Your Honour in detail to, and I should indicate, I won't take Your Honour in detail to the decision in Frugniet, other than to say that it was suggested that that decision is confined to its particular context because of a comment at paragraph 7 that the court wasn't willing to make a application in all non-judicial proceedings.
I'm sorry, you're breaking up, Ms. Edwards. I think it's when your head goes down to look at something, we don't get the sound as, it breaks up.
Apologies, Your Honour, I just need to lay my hands on the decision.
Looking at Frugniet.
Looking at paragraph 7.
Okay.
The court was invited to make a broad ruling, and the court declined to make that broad ruling, particularly in the context of differences in federal jurisdiction. But what we would say is the significance of Frugniet is that its analysis is the same in the sense of saying that it's not open to a court to apply Pine Board as if Daniels and Rich had never happened. And that at paragraph 52 of that decision, the court said, the passage from Daniels effectively determines the meaning that can be given to Pine Board and Sorby for the purposes of this case, and it's not open to regard Pine Board as continuing to be authority, if it ever truly was, for the proposition that the starting point is that penalty privilege is if capable of applying in a non-curial setting, subject only to statutory interpretation leading to its non-application or abrogation. And we would say that that analysis and that conclusion is not obiter, but fundamental, and also emerges from independent analysis of those High Court decisions. So while we do respectfully rely on the skillful reasoning of the full federal court in that case, we would suggest that that emerges, if Your Honour would look at the same case the same way. And again, at paragraph 53, it states that it's reasonably clear that penalty is not even a substantive rule of law that must be found to apply in a non-curial setting. And finally, Your Honour, in that decision, we would respectfully adopt the analysis that at 78, 79 and 80, make clear that it's simply not permissible for a primary judge to follow Morris and Pine Board without taking into account those significant qualifications. And Your Honour will see it right at the top of that page at 76. In substance, the question turns on whether Her Honour was entitled not to apply the obiter by the High Court in Daniels and Rich and instead rely upon Pine Board, Sorby and Morris. And our submission is, with respect, that is what's happening today. The plaintiffs are asking Your Honour to disregard the comments of the High Court in Daniels and Rich and apply select passages in Pine Board and Morris as if they didn't occur. And so our final proposition is we would respectfully adopt the reasoning of the full federal court as to why that's not permissible for a primary judge, and then say that that is precisely with respect to what His Honour Justice Blue did in Bell, which is that he put to one side the decisions of Daniel and Rich and applied Pine Board. And Your Honour's been taken to this judgment in detail. But if I could just take Your Honour to the passage at paragraph 163. Is that right? Where His Honour says there's an obvious tension between the decisions of Pine Board, Sorby and Morris on the one hand, and the seriously considered obiter remarks by the High Court in Daniels. So His Honour's not taking issue that Daniels is seriously considered dicta at 163, but he says that it's preferable that this tension be resolved by an authoritative decision of the High Court, and it's not essential for him to decide the question. I do not do so. But in fact, that's, with respect, precisely what we say he does do. He wholly applies the reasoning in Pine Board that's been overturned in Daniels, the analysis which follows, starting at the start of 498.
498.
Yes, so at paragraph 1.
Sorry.
And you see His Honour there states that he considers the coroner's reasoning to be erroneous because it takes the approach adopted by Justice Brennan rather than the approach adopted by the plurality. But the only reason that Justice Brennan's approach was erroneous was because he made an assumption which wasn't made out in the first place, which was that penalty privilege was a fundamental common law right. And when His Honour says that the approach that should have been adopted was that of Chief Justice Mason, Wilson and Dawson, is expressly endorsing the reasoning that was applied in Pine Board.
Contrary to the reasoning in Daniels.
Yes, thank you, Your Honour. and then goes on at 168 to make the point that Your Honour has already, I believe, observed today, which is His Honour also says that it might be different if self-incrimination and legal professional privilege.
Yes.
Yes. And then what follows is, and Your Honour would see this particularly at paragraph 170, is that His Honour wholeheartedly applies the reasoning in Pine Board by saying it's a common law right. And then essentially refers to penalty privilege as being on like terms as self-incrimination and legal professional privilege. And so to refer back, the reasons that I took Your Honour to those passages with respect both to legal professional privilege in Daniels and also to Justice Murphy's commentary in Daniels is that it's very clear that they can't be put on an equal footing. And so a submission in this respect is that Justice Blue has effectively fallen foul of what the full court and the federal court said in Fragnier was not a permissible approach to reasoning. However, we would note respectfully, Your Honour, that whilst Bell could be criticised on this basis, we don't think that it's necessary for Your Honour to necessarily make a ruling that Bell be on the basis that it's distinguishable because of the substantial differences between the legislation in South Australia at the relevant time and the legislation in the Northern Territory.
But this is set out more fully in your written submissions.
Yes.
Isn't it? Yeah. Can you, what page, what paragraph is that?
I'd need to bring it up, Your Honour, because I don't have those submissions in front of me at the moment. But can I just add to that, Your Honour, that the most significant distinction between Bell and the South Australian legislation and the Northern Territory legislation is that the decision in Bell didn't create that lopsided absurdity that the High Court has repeatedly made reference to in Pine Board and Daniels, because the effect was to preserve three privileges: self-incrimination, penalty privilege, and legal professional privilege. However, we would submit that the ultimate effect of His Honour's approach was to make the coronial system unworkable, because those confirmation of that privilege made the task impossible, and we would refer to the second amending act that came in shortly after the Bell decision.
Well, the effect of the Bell decision on the coronial system in South Australia is not something I need to comment on, is it?
It's not, Your Honour. It's safe to one extent, which is a comment is made in when dealing with the issue of abrogation and intendment. A comment is made by the plaintiff that all Australian jurisdictions have privilege bars that operate within them. There is no coronial jurisdiction in Australia which has an absolute bar available for self-incrimination and penalty privilege. And in our submission, that's because it would be impossible for a coroner to discharge their statutory duties if both were expressly preserved. But I respectfully agree with Your Honour that we're getting beyond what we need to for the purposes of this decision.
Yes, thank you.
Those are the submissions, unless I can assist Your Honour further.
No, thank you. Thank you very much, Ms Edwards. Right, so where are we? It's 4:20. So we have, 10 minutes. What's the preferred course of action? We do have tomorrow at 10 o'clock if we need to continue. So it's probably Naja next, would that be right?
Your Honour, Dr. Freckleton is senior to me, and
Oh, I see.
I'd defer to his seniority if he wished to commence this afternoon.
Dr. Freckleton, I'll leave it up to you then, in that case. A, do you want to go before Naja? And B, if so, do you want to start this afternoon or 10 o'clock tomorrow morning?
Thank you, Your Honour. We'd prefer that Naja go first, and given the hour, it may be most useful to commence in the morning. We won't be lengthy. We just want to make a few short points to Your Honour, putting together some of the strands that we've heard.
All right. Well, I think we'll have plenty of time. Are you content with that?
I'll be probably more efficient if I start in the morning, because my speaking notes,
Yes.
if I revise them in light of everything that's already been said, will be much shorter, and therefore will save time by finishing early.
Yes, all right. I think that's a very wise course to adopt. We'll do that. And I should just check with Mr. Bowe. Are you content to go last?
I should go last, Your Honour, so I am content to go last.
And if we start at 10 o'clock, that's still going to leave plenty of time
Absolutely.
for your submissions, is it not?
It will, Your Honour.
All right. Well, thank you for that. We'll adjourn the court now.
Silence all stand. This on the court now stands adjourned.
We get the transcript circulated?
Yes.
Great, absolutely.
They would take probably.
Fudge?
Did they say that transcript will be circulated?